to the Special Magistrate virtual hearing for November 19th, 2020. All of our code officers have been previously sworn in. Our first case is on page 3. Inspector Paulette Del Grosso. Case number CE 2009-0759, case address 1620 Northeast 5th Court, owner Jeffrey D. Camp. Property was posted 10/28/2020 and posted at City Hall 11/5/2020. Again, our first case is on page 3. Inspector Paulette Del Grosso. Case number CE 2009-0759, case address 1620 Northeast 5th Court, owner Jeffrey Camp. Property posted 10/28/2020, posted at City Hall 11/5/2020.
Thought so. Yeah. Am I up?
Give us one moment, Paulette, as the respondent signs in.
Is this?
Jeffrey, could we get audio check? There you go. Nice.
Good morning, Jeffrey. Can you please raise your right hand?
I don't think I have audio from him.
Hello?
There we go.
Hello?
We can hear you. Good morning. Can you please raise your right hand?
Can you see me?
Yes. Can you raise your right hand only, please?
It's cutting in.
Do you swear and affirm to speak the truth at today's hearing? Jeffrey?
Yes.
Okay, go ahead, please. Thank you. Go ahead, Paulette.
He has low.
Yes.
Thank you.
He has low internet, so just give him some time to respond.
I can't hear anything though.
How'd you know, right? Raise your right hand.
Paulette, you can go ahead.
Thank you. Paulette Del Grosso for the City of Fort Lauderdale, presenting case CE 2009-0759 for property located at 1620 Northeast 5th Court. I inspected the property on September 21st, 2020, and posted it with a nuisance notice the following day. It was cited for the following violation, 18-1. There is a violation at this property that is creating a public nuisance. It is being maintained in such a manner that the property is or may reasonably become infested or inhabited by rodents, vermin, or wild animals, or may furnish a breeding place for mosquitoes, or threatens or endangers the public health, safety, and welfare, or may adversely affect and impair the economic welfare of adjacent properties. There is debris left in the front yard, and the backyard is overgrown. The initial complaint came from a neighbor indicating the backyard is severely overgrown. The entire property is full of outdoor storage, overgrowth, and a beehive, as well as numerous other nuisances. The owner, Jeffrey Camp, has been in contact with me via email, text, and phone throughout the past 2 months. He has made an attempt and some progress to clear the property. However, following a pre-hearing inspection on both Tuesday and Wednesday of this week, I cannot attest the violation is cured. There remains significant overgrowth, clutter, and an active beehive on site. Therefore, the city is requesting 10 days to comply or a daily fine of $150 for the violation.
All right, thank you. Mr. Camp?
Yes.
Did you understand what the
Can you hear
lady
me?
said?
Yes.
All right, tell me what, this is your magistrate. Tell me what you think I should know about this. You obviously have a problem.
Correct. And I'm well aware of that. Obviously, you're aware that the house caught on 25th of May. I'm still working out the claim with the insurance company. And I was advised not to disrupt anything that could be considered evidence in the matter by my attorney. Although that doesn't explain the stuff in the yard. I get that. So there's been a lot of, these pictures are a little outdated. There's been a lot that has been cleaned up. I've been working on it, focused on it totally for the last week to my COVID positive in September and loss of work. And the work for the elections, I've been quite busy up until very recently. So I'm not working now. This is my full-time effort to get this all clean.
All right, for the record, I find the violation does exist. 10 days to comply, $150 per day thereafter.
Thank you, Your Honor.
Thank you.
The driveway and
Okay.
Thank you. Our next case is on page 5. Inspector Lois Tarosky, case number CE 20071039, case address 1730 Southeast 13th Street, owner Lucky Poncho Investments LLC, property posted 10/15/2020, posted at City Hall 11/5/2020.
can you hear me?
Good morning. Sorry, this is Kevin Jackson on behalf of the respondent.
Good morning, Kevin. Can you please raise your right hand so I can swear you in? Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you. Go ahead, Tarosky.
Good morning, all. This is Inspector Lois Tarowski for the city. This is case number CE 20071039, address 1730 Southeast 13th Street. This property was first inspected on 7/27/2020. The following violation was discovered. 47-19.1.c. There are boats docked at this vacant lot. There is no primary use for this property. A pre-hearing inspection took place on 11/17/2020, and the violation remains. Before the city requests a time frame, I'll go ahead and let Mr. Jackson speak on behalf of the property owner to know what he would like to do at this point.
I appreciate that. Just as a little bit of background, Mr. Block and his family have owned this property for 30 or 40 years. During the majority of that time, there was a structure, there was a house on this property. It has recently been demolished with the intent to build another house. There are engineering plans in the works, drawings in the works. The house just hasn't been built yet. Obviously, this came about and Mr. Block is aware that he has to remove the boat from the property because there's no longer a structure on the property. He's just having a difficult time finding a place to put the boat due to COVID and due to the fact that I guess there are limited spaces in marinas in order to dock a boat. He understands that he needs to move a boat. He just asks for additional time. He asks me to ask the magistrate and the panel for an additional 90 days to allow him to move the boat to a safe location. Again, he understands that this is his responsibility. He needs to do it. He's just having a difficult time finding another location for the boat. He does visit the property regularly, visits the boat, tinkers around with the boat. So it's not like it's just sitting there. And but there is no structure on the property. He understands that. He would just like some additional time to be able to find a location for the boat.
At this point, the city wouldn't mind granting an extra 30 days, but beyond that, this is complaint driven. It's been on the property for some time now. Property owner has been aware of it even prior to actually getting cited for this violation. So at this point, I think 30 days should be ample enough time to secure a location. 35 days. And a fine of $100 a day thereafter.
Okay. All right, thank you very much. For the record, I found the violation does exist, 35 days to comply, $100 per day thereafter. Thank you.
Thank you very much.
Thank you.
Magistrate, we're going to call the previous respondent back into the room as his connection cut out right when you gave the ruling. So we're asking Mr. Jeffrey Camp back into the room so that he can hear his ruling and understand.
Page 3.
I'm having a very hard time hearing her.
She's recalling the first case because he couldn't hear, his computer froze. So this one. She's recalling it so you can tell him what the ruling is.
Okay.
Unfortunately, he's still having technical difficulties, so we're going to move on. Our next case is on page 19 and page 23. Inspector Linda Holloway and Inspector Gustavo Caracas. Case number CE 19081835 is on page 19, and CE 19061667 is on page 23 for property address 1113 Northwest 11th Place, owner Kappa Homes LLC. Case number CE 19081835 was first heard on 1/16/2020 to comply by 1/26/2020, suspended 3/16/2020 to 9/4/2020. One section not complied at $100 per day, $12,300 accrued. The city is requesting full amount and fines continue to accrue. On page 23, case number CE 19061667. This case was first heard on 1/16/2020 to comply by 1/26/2020 and 2/20/2020. Suspended 3/16/2020 to 9/4/2020. 7 sections complied at $50 per day, $24,500 accrued, and the city is requesting full amount.
Good morning, Mr.
Yes,
Bell.
good morning.
Can you please raise your right hand? Do you swear and affirm to speak the truth at today's hearing?
Yes, yes, I do.
Thank you.
Yes, good morning, Your Honor. I represent Kappa Homes. My client,
Mr. Valdez,
yes.
I apologize. We have to hear from the city first.
Oh, I apologize.
Good morning, Your Honor. Inspector Linda Holloway, presenting case CE 19081835. Property address is read. The violation, 18118, is not in compliance. The city's asking for the full fines.
All right. And let's go to the one on page 23.
He also wants to hear from Inspector Caracas as well on page 23.
Page 23.
Katrina, shouldn't we take them separately because one's in compliance and one isn't?
He is going to take them separately.
Okay.
I follow. All right. Okay.
Yours says
All right.
not.
Counselors, state your name for the record, please.
My name is Juan Valdez. I represent Kappa Homes LLC.
Okay, your turn.
Are you ready for me to present my case?
Yes, sir.
So on case number ending in CE 19081835 regarding the pool violation, it's basically going to be the same for both cases, but my client Kappa Homes purchased this property via foreclosure back in March of this year. Shortly thereafter, with the pandemic, they haven't been able to take many actions because the prior owner's son was squatting on the property and wasn't allowing them access to the property in order to remediate any of the outstanding violations. If I may take us back one quick second, before my client purchased, there had appeared to be a fire at the property, which caused some damage. The son, the owner deceased, the son who resided there squatted, didn't take care of the property. My client purchased in the foreclosure sale, couldn't remove the individual for quite some time because there was no removal proceedings afforded by the civil court. We couldn't evict him or remove him. Eventually, we were able to get him removed, and my client commenced to take the remedial work necessary in order to correct the violations. Both of these violations, and they were originally heard prior to my client acquiring ownership, so we were unaware of their existence. With reference to the pool has been enclosed, but because of the fire that occurred prior to my client's ownership of the property, FPL has disconnected any electricity to the property. So the pool pump that's there cannot operate because there is no electricity feeding into the property. So my client is maintaining the pool on a weekly basis in order to keep it from the stagnant green color. However, they can't take any other action because there is no pool pump servicing because there's no electricity on the property, and the electricity is scheduled to come on board at the beginning of next year in January, which is their next scheduled appointment with FPL. So my client has taken all steps that it can within the time and scope because they didn't have access to the property, and they've enclosed the area so it's no longer a hazard, and they're treating it on a weekly basis in order to prevent the discoloration of the pool and for it to become a hazard. No. And this violation occurred prior to our client's ownership. So we're asking this court and the magistrate to reduce and remove the violation and the fine that's associated with it, because we are trying to comply within our capabilities. We don't have power right now, so we can't have a pool pump running.
Your Honor, if I may, this property Upon my reinspection on back in February, when I noticed that a new owner had taken ownership of the property, it was in fact the workers who were hired by the new owners that had given me access to the property to view the pool. So, there was access given to the property, but nevertheless, with that being said, this pool without electricity, the pool can be covered by a tight fitting, professionally installed pool cover. So the pool can be brought into compliance by those means.
All right, as to this case, I'm going to, you're still not in compliance. So I'm going to impose the fines and they'll continue to accrue.
Thank you, Your Honor.
Inspector Holloway, so you want them to put a cover over the pool?
Yes, tight fitting, professionally installed.
Can we have some time in order to get that done? So that can you suspend the fines? Because again, my client is trying to improve the property and bring it into compliance and is investing a huge amount of money into this property. And now we got to go out and tight fit the pool, all the while still have these violations accruing fines. It's not like my client's just sitting idly. They're heavily investing in the property to make all the other additional corrections to the property. There's been busted windows, roofs, electrical issues. So this is imposing a burden on my client when we're just trying to make the property better.
Okay, it's also a health issue.
Right, exactly, Your Honor, which is what I was about to say. This is an ongoing problem, and it is life safety and health issues. So the sooner that your client can get that done, the better, and the fines will stop. So you just, if you could advise them that once they get that cover done, if they could just give me a call, and then I can come out, re-inspect the property, and we can stop the fines that way.
Okay.
Thank you.
Thank you.
Thank you, Your Honor.
Inspector Gustavo Caracas for the case on page 23.
Good morning, Your Honor.
Good morning.
Inspector Caracas, on behalf of the city, case address numbers as read on record. I'll read it anyways. Charlie Echo 190616667, located at 1113 Northwest 11th Place. This case first came before Special Master on January 16, 2020, where evidence was presented and the magistrate found for the city. These violations were first cited on July 15 of 2019, and a total of 19 re-inspections were made to the property. There were conversations by phone and in person with the actual property owner. During these conversations, the status of the violations and corrective actions were discussed. We do have compliance on my case, sir. We have compliance. And basically, we're asking for the 20% of the fines that have been accrued, sir, which turns around to about, what is it, 20, which is about 6,000 and change, I believe, sir.
All right, should we address these today or defer until we have compliance on the pool?
Sir, these are two separate cases, sir. 667 is one case and the pool case is another case, sir.
Okay, all right. On
The
behalf of the
fines,
owner-
20%, I'm sorry, 20% of the fines is $4,900.
Your Honor, again, if I may, the initial hearing, which triggered the accrual of the fines, occurred prior to my client obtaining ownership. And since my client has attained ownership, they have tried to remedy the situation. by taking the remedial actions necessary. Again, they've been obstructed by the squatting tenant that was there, and they continue to take the remedial actions to make the corrections. We ask for the court to take that into account as my client's trying to improve the property as best they can.
Okay.
Your Honor, if I may, I have been in contact with the lady owner since the beginning of March. And if not on a weekly basis, on every 30 to 45 days, and explaining to the owner what needs to be done. Myself going in there and pinpointing out all the things that require to be done as well. Also, I've been in contact with the contractor as well on site. And I have been called upon and explained to them what needs to be done. I think the city has actually given ample time, and they actually bought the property knowing as well that they actually had a violation on it as well, sir. So the city stands at 20%, sir.
All right. I agree with the city's position, and I'm going to reduce the fines to 20% of the total amount, or $4,900.
Thank you, sir.
Thank you.
Okay, will we be given a written notification of these
Yes.
orders? Okay.
Yes.
Okay, thank you, Your Honor.
Thank you.
Yeah.
Thank you. Our next case is on page 17. Inspector Gail Williams. For case number CE 19071855, case address 521 Southwest 10th Street, Sabrina and Azem Visram. This case was first heard on 11/7/2019 to comply by 11/21/2019, suspended 3/16/2020 to 4/20/2020. One section complied at $50 per day, $5,800 accrued. This is a request for the special magistrate to vacate the order of 9/23/2020 and rehear the case.
Good morning, Your Honor. Inspector Gail Williams for the City of Fort Lauderdale, presenting case CE 1907.
Hold on one second, Gail. We have to swear in the respondent.
Good morning, Omar. Can you please raise your right hand? Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you. Go ahead, Gail.
Inspector Gail Williams for the City of Fort Lauderdale, presenting case CE 19071855, address 521 Southwest 10th Street. Case was originally presented to Special Magistrate on November 7, 2019. For the following violation were cited: 47-21.15.A.1.A. The city is requesting full amount to be imposed.
Okay. All right. On behalf of the owner.
Good morning, Your Honor. Omar Gerald on behalf of Ms. Visram. Ms. Visram, there's a little bit of miscommunication for missing the first hearing. She received some correspondence indicating the case was closed, but she didn't realize that the city was moving forward with the fining process. She has brought everything into compliance, and then I, on behalf of Ms. Visram, would also rely on Florida Statute 163.045, indicating that a local government may not require, in pertinent part, notice, permit, fee, mitigation for pruning or removal of a tree on residential property if the property owner obtains documentation from an arborist certified, indicating that the tree presents a danger to persons or property. That's what Ms. Visram did. So on her behalf, we're requesting that the fine be vacated and waived.
Okay. It's on the agenda as vacate order of September 23rd, 20 and rehear.
Yes, sir. Yes, Your Honor.
Agrees with that. We're gonna.
I apologize, Your Honor. The volume on your mic is kind of low. Could you repeat that? I apologize.
He didn't hear you. He didn't hear you. Repeat what you said.
All right. Okay. Okay. City's request is for imposition of the full fine. Okay, this goes back to November of 2019. Okay. All right. I'm going to grant the city's request and impose the full amount of the fines.
And judges, is there any position as it relates to Florida statute 163.045? I can't hear anything. I don't know.
Nothing is being said.
Oh, okay. And I'll just point out that this particular statute went into effect of June of 2019, which makes it impermissible for the local governments to impose this, the fine, require a permit, or impose a fee for trees that present a danger to persons or property.
Your Honor, if I could briefly respond, Rhonda Montoya Hassan with the City Attorney's Office. Statute doesn't exactly say that. The statute, and if I can just read it, Section 1 says, a local government may not require a notice, application, approval, permit, fee, or mitigation for the pruning, trimming, or removal of a tree on residential property if the property owner obtains documentation from an arborist certified by the International Society of Arboriculture or a Florida licensed landscape architect that the tree presents a danger to persons or property. Section 2 says a local government may not require a property owner to replant a tree that was pruned, trimmed, or removed in accordance with this section. And then finally, Section 3, just for full disclosure, this section does not apply to the exercise of specifically delegated authority for mangrove protection. Nowhere in that statute indicates that the city cannot fine a property owner for a violation. What this says by the express language says that we cannot charge a fee or require a permit or require that they replant if that documentation is provided. It does not say that the city is unable under 162 proceedings to issue a notice of violation.
But my client did present the letter from the certified arborist and received correspondence from the city indicating that the case was closed. And then that's where the confusion arose as to the imposition of the fines. Upon receipt of the letter from the certified arborist and the receipt of the email from the city saying the case was closed, the city then moved forward with the imposition of the fines, which is why my client failed to attend the first hearing because she was under the impression that the case was already closed. I have those emails from the city and I have the letter from the certified arborist, and it should be part of the city file. So even though that she had that letter and the city cannot require a permit for the removal of said tree, she applied for the permit regardless, tried to come into compliance. That is why she came into compliance upon receipt of the certified letter from the arborist, applying for the permit, which per the statute she didn't need to apply for, just in an effort to come into compliance. But based on the letter of the certified arborist, based on obtaining the permit that was not required per the statute, she's done everything that she's supposed to do, and we would just request waiver of said fine. I have a letter of the certified arborist here. I could upload it, assuming it's part of the city's file, and I also have the emails indicating that the case was closed.
Your Honor, may I speak? I'm asking Mr. Omar in reference to the information referencing the letter from the arborist and stating that the information, we did not receive that. Can you verify who that information was sent to? Because I did not receive it. Now, I know Christy McCall, the landscaper, was involved also in this case. Was that information sent to her because it was not forwarded to me?
Sure. So I have an email chain from Miss Gail Williams and Miss Christy McCall to my client. The only thing I have here is good morning, Sabrina. I just received confirmation that the case is closed. Please feel free to reach out with landscaping questions, concerns in the future. So I believe she did send that over to Miss Christy McCullough, although that chain does not indicate when the information was sent. If you want to put me on a brief recall, I could see if that was submitted, or I'm not sure if this particular hearing permits it. If you give me a few minutes, I could probably share my screen showing the letter from the arborist if you want to put me on a recall for a couple cases.
It does not really. You're supposed to submit any evidence in advance.
I understand, but this was all already, so we didn't submit it because it was everything that was sent to the city originally. I'm not sure what particular department. So if that's the concern, if you just give me a few moments, I could see where it was sent to, because it might have been sent to Miss McCullough instead of Miss Williams.
Can you send counsel what you have to Inspector Williams so she can review it and then we could recall the case?
Yeah, certainly. I'll do it right now. Thank you very much.
Okay.
So we will recall this case. Our next case is on page 2. Inspector DeAngelis Gibson, case number CE-2001-0906, case address 2617 Northeast 26 Terrace, owner Daniel and Nicole Pacella, property posted 11/2/2020, posted at City Hall 11/5/2020.
Good morning, Mr. Daniel. Can you please raise your right hand? Do you swear and affirm to speak the truth at today's hearing?
Yes.
Okay, thank you so much. Go ahead, Mr. Gibson.
Good morning, Your Honor. Inspector DeAngelis Gibson, on behalf of the city, case and address as read. This property was first inspected on 1/15/2020, where Senior Inspector Suarez cited the property with violation 47-19.2.Q, having a flagpole erected and placed in the swale without a permit. A pre-hearing inspection conducted on 11/18 revealed that the violation remains. The city is requesting 10 days for correction or a fine of $25 a day thereafter.
Oh, you just need a permit.
The owner?
Yes, Your Honor, thank you. So, if you look through the history of this case, we had several inspectors that came out to the house starting over a year ago with Von Malakis. And many times they came out, they inspected the property, they looked at the situation, and they deemed that there was no violation at all. And they closed the case out. And this happened several times. What this really comes down to is this is someone that doesn't like my political views, and this is harassment. And we have a neighbor that just keeps calling constantly about our property, from decorations that we put outside for the holidays to a fence problem that we had after the hurricane. That, in speaking with John Suarez and also Dick Ethan, they put notes in the file that this person has to stop complaining. They just can't keep complaining. These are like frivolous complaints, and they complain constantly. The last part of this is, to this day, I have not been shown where my flagpole is with correspondence to anything. So I don't even know where the flagpole is sitting right now in relation to this right-of-way violation that I have.
All right, Mr. Gibson?
Good morning, Your Honor, again. The flagpole is placed in the swale area where there's a concrete base. It's a telescoping flagpole, and at this point, the flagpole is down and that there's no flag on it. But there still remains a concrete base that has not been permitted to be sit in the swale area.
This concrete base has been on the property since we purchased this property 20 years ago. You can see in one of the pictures that you sent me, where you're trying to compare where this flagpole is to the right-of-way, you can see that there's a tree there. This was uncovered. That's how old that picture is that you're using. That tree, I don't even know where it is. I mean, I remember the last time it was there. So my point is, you know, taking an overhead picture and drawing with a Sharpie marker, showing where this is in relation to my property and the road, I just don't feel that you've proven where this thing is. I don't feel that I'm in the right of way. I don't feel that I'm in any violation here. I'm on my property. And, you know, inspectors have come out and they've measured out with their feet, you know, from different parts of the road and different parts of the properties. And, you know, this is not correct.
All right, Mr. DeAngelis, how was the determination made that it was in this public right of way versus on his property?
Well, when you pull the property up on Broward County Property Appraiser, the lines that separate his property from the line from the public property area would dictate that the flagpole is actually placed in an area that's on the public property area, which would mean that in order for it to be placed in that area, it would have to have a permit.
I don't feel that that's accurate, because there's trees that are on there that you're comparing where my flagpole is compared to a tree. The tree hasn't existed for a decade, or whenever this picture's been taken. So I mean, I think if you really want to go down this route, I think you need to come and do a survey of where this is.
Is the flagpole still there?
The flagpole's telescopic, so when it's windy, I take the flagpole down because it's too strong. This thing there's a sleeve that's been sitting in the ground that we cleaned out with a vacuum, and we put a flag in there. I could take it, in and out every day if I wanted to. It's a very light flagpole, and that's what Suarez and Dick Ethan, they had said that this was a stick pole. And originally, if you look back at the notes, a couple of the violations that were closed, they felt that I didn't even need a permit for this because it was temporary. Then, I mean, we just have a neighbor that keeps complaining, so they keep looking further and further for an issue to violate me.
Right. So the city's concern is the concrete base remains in the right of way. Is that correct?
I don't believe it's in the right of way. And I don't believe that from the diagrams that you drew with this Sharpie marker on top of it. I mean, how is this accurate? How can you take a Sharpie and draw over a picture from some microfiche there's no proof. You have no proof where this flagpole is. Show me the proof and I'll be happy to make a change.
All right. I'm going to, for the record, find the violation does exist. 10 days to comply, $25 per day thereafter.
On what grounds, Your Honor?
On the testimony that was presented. Okay. Thank you very much.
Thank you, Your Honor.
They're just jerks. They don't even care. They don't care.
This is ridiculous. This is a kangaroo court.
Our next case is on page 21. Senior Inspector Wilson Quintero. Case number CE 18081609. Case address 4721 Bayview Drive. Owner Frederick L. Walters. This case was first heard on 9/9/2020 to comply by 10/10/2020. 3 sections not complied at $25 per day, $1,200 accrued. And then additionally, 3 sections not complied at $50 per day, which was an increase from the previous $25, and $3,450 accrued. A total of $4,650 accrued. The city is requesting full amount and fines continue to accrue. We have Mr. Frederick Walters appearing by phone, and neighbor Gary Moses appearing.
Good morning. Can you please raise your right hand? Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you. Mr. Walters, can you please state your name for the record?
Mr. Walters, hit *6 to unmute yourself on your phone. Mr. Walters, hit *6 to unmute yourself.
Good morning, Mr. Walters. Can you please state your name for the record?
Frederick L. Walters?
And can you please raise your right hand so I can swear you in?
Yes.
Do you swear and affirm to speak the truth at today's hearing?
Yes.
Thank you so much.
Good morning, Your Honor. Senior Inspector Quintero, Senior, number 269, on behalf of the city. Case number CE 1A081609, case address 4721 Bayview Drive. This case first came to a special magistrate on 9/9/2020 via a stipulation agreement where evidence was presented and magistrate judge party found for the city. These violations were first cited on 8/22/2018 for the dead tree, and an inspection response was amended on 8/19/2020 when I took over the case and scheduled for a special hearing. On 10/28/2020, a special magistrate Flynn granted the city request, denied the extension, and increased the violation fine. There were conversations by phone and in person with the property owner. The property owner talked to landscaping inspectors and a few people from the city. During this conversation, the status of the violations and corrective actions was discussed. Property owners has been sending me contracts from the landscaping inspector, and he's working towards compliance. The case is not in compliance and is the position of the city, and the fines being imposed are read. Thank you, Your Honor.
Thank you. The owner?
Yes, we've been delayed a little bit because of 3 weeks of backyard underwater. This property requires flood insurance, but now that it's drier, Sherlock Tree Company is coming out Saturday, according to the contract that I forwarded to Wilson. They're coming out Saturday to forward with the cleanup and the other tree trimming.
All right. Okay. 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 Out of compliance, 16 days. All right. I'm going to grant the city's request that the fines be imposed and continue to accrue.
Okay.
Your Honor,
Yes.
my name is Gary Moses. Could I speak? I'm the neighbor here on the south end of Mr. Walters, and I need your help in addressing this nuisance property. He's holding the neighborhood and myself and my wife held hostage by ignoring and not addressing and completing any of the directives by the city over the last couple of years. He accumulates these unpaid fines and just puts them towards a lien on his house. He doesn't do any of the work that's been addressed. He continues to offer excuses. He continues to offer reasons why he can't do things. But at the end of the day, we're in danger. We have a large tree, as you can see on the video, that could fall on our property. We've already had one tree fall on our property back in September. An 80-foot tree fell on our house. He was told to do something about that 2 years prior in 2018, and he didn't do anything. This man just continues to ignore the system, ignore what a good neighbor should be. He's got a lot of unkept debris on our fence. He hasn't cleaned up from the tree. There's the fence line. I can't even address the fence line and put in a new fence because he's got so much tree debris there. His backyard is a mess. It's rodent and vermin, and it's just a nuisance property. He needs to be able to do something. He needs to be mandated to do something. And whatever the maximum fines are, I'm pleading with you, Your Honor, to do this because he just ignores every directive.
All right.
Thank you. I really appreciate the time.
All right. Thank you, sir.
Thank you, Your Honor.
Our next case is on page 17. Inspector DeAngelis Gibson. Case number CE 2006-0050, case address 4771 Bayview Drive. Owners, Amadea and Maria Tenaglia. This property was cited on 6/30/2020 to comply by 7/5/2020. One section not complied at $200 per day. $28,000 has accrued. The city is requesting full amount and fines continue to accrue.
Yes, hold on. I'm having some difficulty. Thank you. Escape. Okay, start my video.
Good morning.
Your Honor.
Can you please raise your right hand?
Good morning. Good morning. Yes,
Do you swear and affirm to speak the truth?
I swear to tell the truth.
Do you
I
swear
do.
and affirm to speak the truth at today's hearing?
I do.
Thank you, sir.
And I also have my client here, Amadeo Tenaglia, who is the owner of the property, and he's sitting right next to me.
I need to swear him in as well. Can you please raise your right hand? Thank you. Do you swear and affirm to speak the truth at today's hearing?
Okay, he's ready. Yes.
Go ahead, Mr.
Okay.
DeAngelis, you can begin.
Inspector DeAngelis Gibson on behalf of the city, address and case as read. I first visited this property on 6/1/2020, and the property was being utilized as a short-term rental during the pandemic without the required certificate from the city. I cited the property with violation 15-272.A, and after citing the property, I have had no contact with the owner, even after numerous letters sent out to the address listed on the property appraiser. There have been several complaints from the neighbors reference to property being rented during the pandemic. And in this last week, I finally heard from the attorney for the property. The case remains in violation based on the
Yeah. Okay.
Based on the advertisement, the city is requesting the full imposition of the fines.
All right, Counselor. Okay, on behalf of the owner.
Yes, good morning, Your Honor. As you can see, my client is 87 years old. 88, I apologize. And yes, you have it right here, Your Honor. I'm gonna be to a Mr. Ivan Poroshenko and Alexander Boyko. And I believe when he finally was made aware, or at least his daughter was made aware that there were violations, that they forwarded a copy of the violation to the tenants. And the, hold on. Am I still on? Can you hear me?
Yes, sir. We can hear you fine.
Hello?
Yes, sir, we can hear you.
Hello? Oh, okay, great. Thank you. Thank you. Thank you. Thank you. I'm not seeing the video, but I guess that's all right. Anyway, contacted the tenants in the meeting, and they assured us, I just emailed some text communications June 24th or 25th to Your Honor, where they absolutely guarantee everything was being taken care of and they were in compliance. Now, of course, my client doesn't get around that much anymore. So we kind of relied on their representation. Then I spoke with Mr. Inspector Gibson and got a grasp of the situation. I explained it to him as best I could. And we started, and also the tenants had not paid rent for I don't know how long. So far, up to this point, they owe $13,200. So I started eviction proceedings. And I have not been in touch with the tenants. They will not communicate with me. I have asked for the evidence of compliance. They said that they spoke with Inspector Gibson. I suspect that may be untrue. I am asking, Your Honor, that you let us continue with our eviction proceeding, eject the tenants, and cure the defect that we did not really know was ongoing, and give us time, Your Honor, to let this play out in court. I suspect we'll be able to get a writ of possession within, I would say, 2 weeks. Did everybody hear that?
Yes, sir.
Hello? Oh, did you hear that? I'm sorry.
Yes, sir. It's just a little difficult to understand what it is that you're saying with the music playing in the background.
I'm sorry. Oh, the music. Is there any way?
Yeah.
All right.
My unit, I'm having a hard time
Hold on
hearing.
one second. Yes. I understand, Your Honor. Hold on. We're trying to correct that situation. I had to meet my client in a public place, and can he turn that off? Is it because they're... All right. Can you hear me now, Your Honor?
I can hear you much better now.
All right. Well, that's... I'm right on top of the speaker. I think that helps. Your Honor, I don't know how much you heard of the presentation, but I just recently learned myself, I was just retained by Mr. Tenaglia of this violation last week, and I contacted Inspector Gibson immediately. Now, Mr. Tenaglia, as you saw, I think you saw, is 88 years old. He does not get around that well. After the first citation was issued by Inspector Gibson, the tenants, he leased it to two individuals. Hold on. He leased it to Ivan Opanishchenko and Alexander Boyko. They sent the notice to the tenants, my client and his daughter, and the tenants sent back a text message, which I just emailed to Special Magistrate at fortlauderdale.gov, and they swore, well, they didn't swear, but they said in the text that they were in full compliance. We spoke to them again recently, and they said that they had spoken with Inspector Gibson, and they were in full compliance. Apparently, this is untrue. So our remedy at this time was I suggested that we start eviction proceedings, which we did. We posted the 3-day notice, and there was a lease attached. I tried to upload them, I believe, last week. I don't know if Your Honor has them. And we are proceeding with the eviction. We should have a writ of possession. It's not, after we posted the 3-day notice and after we filed the complaint, we have not served the summons yet. From what I understand, they vacated the property and they're not letting any other tenants in. Again, Inspector Gibson said that they're still advertising, and we had no knowledge of that. We did bring that up to the 2 tenants, and they said they took care of that as well. And Your Honor, quite frankly, my client does not have the capacity to run over and check on this. He can't drive, and his eyesight is not that good. So we're doing everything we can by evicting these tenants and barring them from continuing whatever they're doing over there.
Your Honor, if I could, Rana Montoya Hassan with the City Attorney's Office. As Your Honor knows, 2 things. One, property owners are ultimately responsible for the conduct of their tenants. There certainly may be a civil avenue for damages in an eviction action, which is really not, doesn't involve the city and is not within the purview of the magistrate. Moreover, Your Honor, obviously this is coming to you before you as a citation. The appeal deadline was in July. There was no appeal contesting the validity, and based upon counsel's remarks, it doesn't seem that he is denying that the property was used as a vacation rental. Further, Your Honor, as you know, based upon the date of the citation, this was at a time when vacation rentals were prohibited from being operated because of the health and safety issues regarding the pandemic. So I would just support the inspector's request to impose the fines. Again, the appeal time has run and it's still being advertised as the inspector stated, and so the fine should be imposed. Thank you.
Your Honor, another matter that should be brought to the court's attention. I don't know if you received the photograph of the text that we received from the tenants stating they were in full compliance. There was at the same time a court hearing, and I know my client will not like hearing this, but for guardianship. He was alleged before Judge Green to be incapacitated, and to a certain extent, we have that resolved. So he didn't, we relied on the tenants' representations, and apparently, obviously, we didn't see that there was a need to appeal because we relied on their representation that they ceased renting during the COVID crisis. There was I believe, a period of time where they were not allowed at all to lease any property under those conditions. But as I said, I would ask special indulgence from Your Honor because my client, as I said, is just going through. I think that, that it's a little hard right now for him to have such a serious fine imposed and any lien on that property, because we're going to need that property basically to support his health care. The text message from the client or the tenants stating that they were in full compliance. I sent it to I sent it to Special Magistrate at Fort Lauderdale.
Or you're cutting out again.
Just now. Just saw it.
All right, Inspector Gibson.
Did everybody hear me?
Yeah, I need to talk to the inspector a second. Inspector Gibson, anything in your records reflect that there was communication telling the owner that he was in compliance?
No, sir. I never had any contact with anybody up
everybody
until I
hear
spoke to the lawyers, and I just spoke to the lawyers on Monday of this week.
All right. And what does he need to do to come into compliance?
He just basically needs to shut down the advertisement for the vacation rental and ensures that the property isn't rented on a short-term rental. And he also needs to just send us a letter stating that he does not use the property as a short-term rental.
All right.
You can't do it affidavit.
That should not take a long time.
I don't know what the hell's going on. Hello?
Yes.
Kwame? Yes, Your Honor. Hello?
Okay, I don't know if Mr. Fasciola is there or not.
Yes, sir?
Can you hear us?
Yes, now I can.
Okay, all right. Well, here's what I'm going to do. You've got $28,000 in fines already. I'm going to grant a 7-day extension and stay the fines as of this date. Done.
All right, Your Honor. Will they be forgiven or?
That will be addressed once compliance is achieved.
All right. So we have 7 days and we will be able to do that. We are pushing ahead with the eviction and we'll do what we can. Well, we will have that removed from the advertising. Oh, Your Honor.
Yes.
And we didn't see it on Airbnb this morning, as a matter of fact.
All right. Thank you.
Thank you, Your Honor.
Okay.
Thank you.
All right, we have 7 days to make sure that these are out.
Our next case is on page 16. Inspector Manny Garcia. Case number CE 200-71071. Case address 2070 Northeast 63rd Street. Owner Nancy Elder. This property was first cited on 7/26/2020 to comply by 7/26/2020. One section complied at $250 per day. The city is requesting full amount be imposed. Additionally, on page 16 is case number CE 200711242 with Inspector Patrice Jolly for the same address, 2070 Northeast 63rd Street. This property was cited on 7/28/2020 to comply by 8/2/2020. One section not complied at $200 per day, $21,800 accrued, and the city is requesting full amount and fines continue to accrue. Hold 1 second, Manny. I believe the respondent may have dropped out. We'll recall the case until once she logs back in. Our next case is on page 29. And 30 for Inspector Manny Garcia. Case number CE 1807161, case address 3204 Davie Boulevard, owner Soraya Holdings 2 Inc. This case was first heard on 8/13/2020 to comply by 11/19/2020. Two sections not complied at $100 per day. Fines are due to start tomorrow, and this was in order to reappear. On the same page is case number CE 1808198, case address 3300 Davie Boulevard, owner Soraya Holdings 2 Inc. This case was first heard on 8/13/2020 to comply by 11/19/2020. Two sections not complied at $100 per day. Fines are due to start tomorrow, and this was in order to reappear. And on page 30 is case number CE 19020960, case address 3200 Davie Boulevard, owner Soraya Holdings 2 Inc. This case was first heard on 8/13/2020 to comply by 11/19/2020. Two sections not complied at $100 per day. Fines are due to start tomorrow, and this was in order to reappear.
Good morning, Carly. Please raise your right hand. Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you.
Thank you.
Good morning. Good morning. This is Code Enforcement Supervisor for City of Fort Lauderdale, Reggie White. I'm presenting the case for Inspector Garcia.
Sorry.
Oh, go ahead.
Sorry, for 1 second. We have one other respondent.
Yeah.
Okay.
It should be Brett DeCapito, I believe, is joining. He was on the line earlier.
Good morning, Brett. Can you please raise your right hand? Do you swear and affirm to speak the truth at today's hearing?
Absolutely, yes.
Thank you. You can go ahead, Mr. White.
Good morning. Code Enforcement Supervisor Reggie White, presenting the case for Senior Inspector Manny Garcia. This is in reference to the cases CE 18071161 at Davie Boulevard, Sarah Holdings. This case was brought before the court on August 13, 2020, and the magistrate found them in violation. The city is not opposed to an extension of 35 days. The property has made significant improvements in regards to landscaping and planting of trees, as the photos do depict.
Thank you. And just to be clear, there are three case numbers related to this property. I want to make sure all three are captured by this. It was the one that the inspector had just mentioned, as well as CE 19020960. And then the third one is CE 18081968.
That's correct. Yes.
Thank you. So we appreciate your review of this and the comments that significant progress has been made. Mr. DeCapito, who is here, is the head of the landscape contracting work that has been ongoing at the property. And as you can tell, we have made significant progress. The project at issue is a complete revamping of the landscaping, and then also some work on the curbing and parking lot, which is to be done once the landscaping work is complete. As part of this project, there was a removal of, I want to say, roughly 50 oak trees. So there's quite significant the work to be done, and we have made good traction. Part of the reason for the delays is, not surprisingly, as I'm guessing everyone at today's hearing is aware, we've just had tremendous amounts of rain that's somewhat unseasonable for this time of year, which has really hamstrung the contractor's efforts to get this done. So we can't, of course, do the parking lot repairs until the landscape work is complete. You know, 35 days, we appreciate that and your willingness to do that. We are going to continue to work expeditiously to get this done. But of course, if the weather does not cooperate, we will, you know, we may need to come back for an additional few weeks for an extension. But again, we will continue to keep our foot on the gas on this and try to get it done as quickly as possible, weather permitting.
Okay, so we're making substantial progress, which is what I'm looking for when I order a reappearance.
Yes, Your Honor, and that's what we'd ask if we could come back in 35 days. And as I say, we will continue to make as much progress as we can. And again, the contractor's on the line if you'd like to ask him questions. But I know from my conversations with him on a weekly basis, they've even tried to go and do some planting work at night, and the rain keeps coming then. I mean, it's just, even in these pictures, you can tell it's just a fresh rain, as we all know, being down here. So if possible, we would ask for a 35-day extension and then a reappearance to then evaluate what remains to be done at that point.
Okay, here's what I'm going to do. I'm going to grant a 49-day extension, which will be January 12th, 2021, with a order to reappear.
Thank you, Your Honor. We very much appreciate it.
Thank you. 54 days.
Thank you.
Thank you, everyone.
Magistrate, we're recalling the case on, well, not recalling the case on page 3. The respondent, Mr. Jeffrey Camp, his connection dropped right at the ruling. And so he's now able to hear and is back in the room. Mr. Camp?
Yes.
On page 3.
Yes. Can you see me?
No, sir, but it's okay. We can go ahead.
Okay.
So the ruling that the judge gave was 10 days to comply or $150 per day thereafter.
I'm sorry, could you repeat that?
10 days to comply or $150 per day thereafter.
Is there any way I can request an extension until the next bulk trash pickup? Because I think by then I can get it all finished. I think that would be December 10th is my next bulk trash pickup.
And I'm sorry, when is the next bulk trash pickup?
I believe it's December 10th. It's the second Thursday of the month. I mean, the code enforcer is talking about a lot of the vegetation. I'm not sure exactly what extent of vegetation she's referring to. So that's why I've tried to meet with her on site, but she never would respond to an appointment time.
Your Honor, if I may, Mr. Camp has been adamant in the past couple of weeks that he has COVID-19. So I believe under the circumstances, you can understand why I chose to meet or I chose to inspect the property without anyone on site. Mr. Camp has a copious amount of not only clutter, but overgrowth, as you can see from the photographs that were taken as late as yesterday that I uploaded for this hearing. Therefore, I think Mr. Camp, if a 10-day or an extension until the next bulk day would not be unreasonable, but I doubt that he will be able to clear all of that clutter and overgrowth simply by using one bulk day service. He will need to have someone come and remove a lot of that, at his own expense.
All right.
Your Honor, if I may, my diagnosis with COVID was September 23rd, and by the Broward County Health Department, I had a 10-day quarantine. That was back in September, October. We're talking about November now, so I have to disagree with the code officer. I am not under any, you know, and we're outdoors. I mean, we could certainly stand 15 feet apart with masks on if that's what she requires. I just would like her to point out what vegetation she's talking about, because my backyard has always been, since they built the townhouses behind me, I lost all my privacy. So I'm not sure exactly what vegetation. As far as all the debris, I definitely have a plan to get all that cleared away, either by moving it to Illinois in the next few weeks or utilizing the next bulk trash pickup. And I certainly think I can get all of that done in one bulk trash pickup for sure.
Your Honor, if I could briefly, the purpose of reconvening it was just to relay your Honor's order. I'm really unsure how anyone in good faith could question the proprietary of overgrowth removal or what needs to be removed from the pictures. It should be pretty self-explanatory to anyone over 10 years old. Further, again, Your Honor, this was just to relay your prior order, not to re-argue the case. The property is in a shockingly disgusting state. I can only imagine the poor neighbors that have to, be next to a property with all of that type of, as the inspector said, copious amounts of trash and debris and toilets and tape and overgrowth and extra trash and everything possible under the sun just from the pictures. So I would suggest, Your Honor, that the 10 days stand, and that once the property owner comes into compliance, we can discuss the fines based upon the timeliness of his actions.
I spoke to the neighbor that complained 2 days ago, and I apologized to him for the state of things. But he did agree that things were definitely much improved, and he appreciated that.
All right, I'm going to stand by the original ruling, 10 days to comply, $150 per day thereafter.
Thank you, Your Honor.
Thank you.
Thank you. Thanks for allowing me to rejoin.
Thank you. Our next case is on page 9. Inspector Mike Sanguinetti, case number CE 20080053. Case address 1711 Southwest 23rd Street. Owner Mike Gigler. Property posted 10/19/2020. Posted at City Hall 11/5/2020.
Good morning, Mike. Please raise your right hand. That's your left hand, sir.
Sorry, just hold the phone.
I'm sorry. Do you swear and affirm to speak the truth at today's hearing?
I do, yes.
So much. Go ahead, Mike. Sanguinetti.
Good morning, Your Honor. Inspector Michael Sanguinetti, City of Fort Lauderdale, presenting case and address as read. I inspected this single-family residence, zone RD15, on August 8, 2020, for a number of complaints, including fence and disrepair. The singular violation cited 9-280H1. The fence at this property is in disrepair and is not being maintained as required. Inspection report was mailed to the property owner as listed on Broward County Property Appraiser on August 31st, 2020, and a notice of hearing posted on property on October 20, 2020. A pre-hearing inspection was conducted November 16th, 2020, showing that the fence is still in disrepair. The city is requesting that the violation be brought into compliance within 21 days to repair, replace, or remove damaged fence with permits if necessary, or a fine of $50 per day thereafter.
Okay. All right. On behalf of the owner.
Hello?
Yes. Your
Oh,
turn to speak.
Gotcha. Yeah, I plan on removing the fence. Unfortunately, I cannot afford to replace the fence after being out of work from March through September due to COVID. So my plan is to just pull it out of there. I've started on it slowly, but unfortunately, with all the rain and weather that we've been getting, that's bad. That entire lot fills up like a lake. My backyard fills up like a lake. And the water table's up so high that trying to work around in there in between rainstorms has been a result of me sinking down like an ankle deep of mud. I'm just requesting more time for it to dry up a little bit, and I get a couple days in between working now where I can actually get in there and get the work done without it being a danger to myself.
Okay. It's hard to tell from these pictures exactly what needs to be done.
So those pictures of the overgrowth, it's really that fence fell down in a hurricane a few years back, and I kind of left it just because it was covered in vines and still created a barrier around the backyard. Basically, all those trees are going to have to get cut out that are kind of on that in front of the shed there, and it ripped out. It's going to take me just a couple of days of work, but like I said, I just need the ground to be dry in order to do that. And recently, that hasn't been the case. Even when we get some sunny weather, it takes a good week or 2 weeks of no rain for that ground to dry up solid enough to even walk on to get that stuff done.
Okay. Are you working now?
I submitted some pictures with the with my identification for this panel that showed the current state of the ground over there and how it looks and how bad the water actually gets when it rains over there.
All right. Are you working now?
Yes, I just started working again in October.
It seems to me 21 days should at least give you some time to make some substantial progress. So I suggest you stay in contact with the inspector, but I'm going to find the violation does exist. 21 days to comply, $50 per day thereafter.
All right, thank you, sir.
Thank you.
Your Honor.
Let's take a 5-minute recess. 5-minute recess.
I'm sorry, Inspector, were you going to say something?
No.
Yep, 5-minute recess. Good.
We're now on a 5-minute recess. We're now resuming today's hearing. Our next case is on page 12. Case number FC 2010010 for case address 5555 North Federal Highway. Owner Core Ridge Presbyterian Church, Inc. Inspector Robert Kersarwich. Personal service was given to this property on 11/2/2020 and posted at City Hall on 11/5/2020.
Good morning, Mr. Nichols. Can you please raise your right hand? Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you. Go ahead, Mr. Kisawich.
Good morning, Your Honor.
Good
Captain
morning.
Robert Sarwich, Fort Lauderdale Fire Marshal's Office, here to present case number FC 201000010 for the property address of 5555 North Federal Highway. If you notice, the first four violations on this case are withdrawn. Today's case will only be concerned with NFPA 113.3.1.1. The fire sprinkler system is in need of service. I visited the property out there, and the fire sprinkler system has been red tagged by their certification company of Dynafire. I did obtain copies from Dynafire of the failed certification report, and there are a number of violations that exist on the system, creating the red tag conditions that exist out on the property. Speaking with property management out there, and understand that they have future expansions in some of the areas where some of the violations exist. A large number of these are going to be from corroded heads that exist in a catwalk walkway that apparently is going to be demoed in the near future. They find it, I guess, a little bit of a waste on the money to have to replace these heads if the area is going to be demolitioned out for future expansion. However, there are other violations that are in there, and I have yet to be able to get confirmation from the certification company of Dynafire as to if the other violations in there that are outside of the breezeways and the walkway areas with the corroded heads have been corrected. I see we do have a respondent, so at this time I'll let him speak.
Thank you very much. Yes. So as you mentioned, the red tag on the system, the majority of those are because of 160 what they call corroded heads for our sprinkler system. All of the other items on there are relatively small things that should not be an issue to get resolved. But after speaking with Dynafire, they said that those little tiny things like adjusting gauges and stuff was not as large of a deal, but those certainly can go into compliance if that's needed. The issue is the 160 exterior heads that you referred to, or the corroded heads that you referred to. So there's, of the 160, about 130 of them are in the exterior catwalk area. So it's all outdoors in a breezeway. We were supposed to break ground on our construction project in June of 2021, but that our campaign got delayed an entire year because of COVID. So we're not planning to break ground in this June, but it'll probably be the following June. But these catwalks will be demolished and replaced with interior areas by that time. And so to spend the $15,000 to replace the corroded heads seems like an expense that we don't want to, put on our parishioners at this time if we can delay that, especially because our campus is for the most part closed right now, and also because they're exterior sprinkler heads, so they're not necessarily indoors. And as pertinent from my understanding with talking with certain fire inspectors, I know some of our breezeways don't even have sprinkler heads. So for whatever reason, the ones that do have the sprinkler heads over the past 30 years have been corroded.
Yeah, typically the outside breezeways over there, if during the plan and design construction phases, discussions are usually made of what's going to occur underneath those exterior breezeways. And if there are activities that where there's going to be storage of use of combustible materials, they do require those areas to become sprinkled, whether they're carports or porticos where vehicles drive through, outside walkways that might be turned into areas where Combustible tables and chairs are set up, whether it be a bake sale or some other type of function that's going on in the breezeways and the walkway. So that's probably the reason why some areas were covered and some weren't with the fire sprinkler system previously.
Right. That's my understanding as well. And 30 years ago, when that part of the building was built, it was used for different purposes than it is today. So they were doing much more handing out of books and materials and things in the exterior breezeways. We don't use those areas for that anymore. So if there's a chance to even rezone that, then we're open to that as well. But we didn't see it as a major fire hazard because we keep all of our other sprinkler areas up to date. This was just the one area. We didn't think it was the wisest use if these are going to be demolished and they're exterior without putting any sort of hazards out there in the breezeways.
Your Honor, if I could, Ronald Montoya Hassan from the City Attorney's Office. Not to speak for Captain Kasarowicz, because I would never presume to do that, but I would say that on behalf of the city at large, I'm certainly not comfortable basically with the request to ignore a red tag system and ignore inoperable sprinkler heads. Again, I understand the expense, 150 inoperable heads for at least a year and a half, maybe longer, who knows? If it's already been delayed a year, I think the city incurs liability potentially in ignoring that. And I don't think the city has the ability to say, we're okay with waiting for demolition that may or may not occur now in the next, now push back an entire year. I just don't think that we have that ability. And I think that red tag system needs to be addressed. It's a critical life safety component of any building. And again, if the building was completely not occupied by anyone, then I would say that's maybe a different story. But again, a fire sprinkler system that is existing, if it was red tagged by the servicer, it needs to be timely repaired.
I'd like to clarify, I don't believe that the fire sprinkler system is inoperable. It just has corroded heads and the corroded heads need to get replaced.
I didn't say.
I'll touch base on that, actually. The red tag indicates that, yes, there are portions of the system that are inoperable. If it was something that was a deficiency that was preventing the system from being activated in the event of a fire, it would receive a yellow tag. If it was free of deficiencies, it would then have a green tag. So yes, a red tag does indicate deficiencies that would prevent the system from operating properly.
All right, Inspector, what's your position?
My position at this time is I'd like to see them move forward at least with their sprinkler contractor, if they wish to obtain services from another licensed sprinkler contractor, to correct the items, let's say outside of the scope of those heads for right now until they can come back in 60 days and give us a further update on it.
Okay.
If they could produce a report where the other violations have been corrected and cleared, then I think at that time we can have those discussions.
Okay, so it looks like we're looking at 77 days.
No,
So February 9th.
no, it's gonna be,
Yeah, 77. Nope,
that would be 82 days.
nope.
It's only be 82. And then if it's gonna be,
Just to clarify, you're suggesting that before February 9th, we would take care of anything that is not the exterior breezeway, so all of the other violations on there?
Yeah, I'd like to see a clean report with the items that are listed as, there's quite a few that are in here, but there's
The major, yeah, there's
home discussion rings in the pre-K2 rooms. There was no access to the nursery 1 at that time. Missing discussion rings on each side of the chapel.
Yeah, those are all
the report that you got from your contractor. I'd be happy to supply it.
Yeah, those are all the exterior breezeways. The only interior ones are the ones that are in the kitchen, and those we can fix in the meantime.
All right, but the replacement of the discussion rings and things like that then need to be addressed. Also, that's missing a 5-year inspection.
Eating at this.
I see that listed on the report.
not on the.
Okay.
It's gonna be on the 9th.
2 gauges, outside riser are expired.
Correct.
Okay, let's do mandatory reappearance on February 9th.
Copy. And if that fails to appear on, can we go for $100 a day thereafter?
Okay, agree.
Thank you, Your Honor.
All right, very good.
Thank you.
Our next case is on page 13, Captain Robert Krasowicz, case number FC 20100022, case address 510 Northwest 7th Avenue, owner MJDC AOA LLC, in care of Milton Jones Development Corp. Personal service was given to this property on 11/2/2020 and posted at City Hall on 11/5/2020.
Hello.
Good morning, Daphne. Please raise your
Okay,
right.
good. Thank you. I just want to make sure I could be heard.
We can hear you. Please raise your right hand. Do you swear and affirm to speak the truth at today's hearing?
Yes, I do.
Thank you so much. Go ahead.
Good morning, Your Honor. Captain Robert Kasarowicz here to present case number FC 201-00022 for the property address of 510 Northwest 7th Avenue. Property was cited in reference to NFPA 1 4.5.8.1. The fire alarm system is not functioning as designed and installed. NFPA 25 13.6.2.1. The required inspections and operational tests have not been made on the backflow preventer device in compliance with, within the last 12 months. I'm happy to report that violation is complied as of yesterday when I visited the property. And NFPA 1 13.3.1.1, the fire sprinkler system is in need of service. Currently, right now, the fire alarm system has no power to it. It's been completely disabled due to a malfunction in the main control board that's on there. Circuit breaker is in the off position. The batteries are disconnected and the building is provided with no fire alarm system that was monitoring the fire sprinkler system and also for occupant notification of the store. The fire sprinkler system had some issues that need to be resolved and currently is not certified with a current certification tag. I see the respondent is here. Let me go ahead and have them come in on the case right now.
Good morning, Daphne Jones on behalf of MJDC AOA LLC. At this time, initially what transpired as a notice of violation was sent to the tenant, which I believe is Save-A-Lot. And Save-A-Lot did not do anything right away. So later on, the owner did receive notice, and that was recent, within the last 3 weeks, and have pushed to get Save-A-Lot to move forward to get those repairs done. But in the event that Save-A-Lot has not and will not get those repairs done, the owner will take full responsibility and get those repairs done. We're just asking for an extension of 60 days if that's possible. 60 to 90 days.
Hey, Inspector?
I'd like to see that time frame cut to 30 days, only because we are talking about an operable mercantile business. There's a lot of combustible materials that are in there. Occupant notification is not going to occur with a fire alarm system that's inoperable. So I'd like to see that time frame come within 30 days. I understand permits are going to have to be obtained probably in order to change out this fire alarm panel or replace at least the main components of it. If they can, I'm sure they can apply for an emergency repair.
My only concern with the 30 days instead of giving us 60 days, we've run into difficulty receiving parts. A lot of parts are unavailable and you cannot get them. So to push at 30 days, we may not be able to get the parts in time. We will get it repaired and bring it up to compliance. But if we can't get the part, it puts us in jeopardy for a fine, of which we just received notice that Save-A-Lot was not in compliance. And particularly with the holidays coming up, my concern is we really need 60 days. if you can help us out with a few more days, we will make sure it gets done.
Your Honor, looking at the age of the fire alarm system, that might be a situation that could occur here. It is an older fire alarm system. I'm not sure how readily available parts are going to be for that. It could end up being something with a total replacement. As stated, we're coming into the holiday season, and typically these mercantile occupancies are overloaded with inventory, and egress and stuff kind of seems to get obstructed with this excess of inventory. So we're going to want to make sure that without having proper occupant notification, short of having a business that's closed, because obviously we don't want that to occur, they need to make sure and have management in there that at least is making sure that the egress ways are open and they're clear, they're unobstructed, and that an over excess of inventory is not going to be an issue.
All right, so the city's request is?
Well, I'm still holding on my 30 days, and I think if they need additional time, they can come back and we can talk about that. But in 30 days, they should know if management's going to step up and take on the responsibility of having this fire alarm system replaced, and then go ahead and bill their tenant depending on what their lease agreement is. And at that time, they'll have a better idea if this is going to be replacement of parts or a replacement of the system.
All right, I'm going to do 35 days or
What's the fine amount?
recommended fine.
$100 a day thereafter.
After 35 days, when we're telling you we may not be able to get the parts.
Okay.
That would be the reappearance. That then they can come back and discuss on that.
Okay. So 35 days is the best we can get, given the fact that we're here with the holidays and it's going to be difficult to get parts.
I understand, ma'am, but stay in touch with the inspector.
Okay.
And if we don't know what the full extent of the curative issues are, so we will get a handle on those, and you can request an extension. But again, stay in touch with the inspector.
And by then, we should have at least a full inspection on the fire sprinkler system and know the current status of that system by then.
Good. Done.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Our next case is on page 21. Senior Inspector Dorian Cologne, case number CE 18120868, case address 2800 West Broad Boulevard, owner 12 SAC Self-Storage Corp. This case was first heard on 5/16/19 to comply by 11/14/19. There are two suspensions notated on the agenda. One section complied at $50 per day, $1,000 accrued, and the city is requesting full amount. Additionally, on page 22 is case number CE 18121594, case address 2800 West Broad Boulevard, owner 12 SAC Self-Storage Corp. This case was first heard on 5/16/19 to comply by 11/14/19. There are two suspensions notated on the agenda. Two sections not complied at $50 per day, $9,400 accrued. The city is requesting full amount and fines continue to accrue on the non-complied violations.
Good morning, Mr. Cease. Can you please raise your right hand?
Good morning.
Do you swear and affirm to speak the truth at today's hearing?
Yes, ma'am. I do.
Thank you so much. Thank you.
Sorry about that. Good morning, Senior Inspector Cologne with the City of Fort Lauderdale. Case number is CE 18120868. The address is 2800 West Broward Boulevard. This case came before the special magistrate on May 16, 2019, where evidence was presented and the magistrate found for the city, given the property owner until November 14, 2019 to comply, or a fine amount of $50 per violation thereafter. There were two extensions given as well. This case is in compliance. However, the dead and missing landscaping violation was out of compliance for 20 days after the extensions that were given. And the total amount accrued is $1,000, which the city is requesting the full amount.
All right, on behalf of the owner.
Yes, sir, I'm here. As far as everything that we accrued a lot of cost at that location to try to get everything up to code. The landscaping did take a while. There was a lot of the rain and everything like that. I really don't have an excuse for it, but it's all in compliance now as far as this case goes. So we would just like to see if we can get a little leniency on the fine. We've just got done paying $15,000 last week's hearing for another case that has to do with this property. But like I said, we are really trying to get this property up to code and get everything accomplished that the city wants.
All right. Okay, as to the first case on page 21, I'm going to impose fines of $1,000.
Thank you.
What's the case number on that, please? The last three is fine.
CE 18120868.
Got it, sir. Thank you.
Okay, so for the next case, Senior Inspector Cloyne with the City of Fort Lauderdale, case number CE 1812-1594. Case address is 2800 West Broward Boulevard. This case came before the Special Magistrate on May 16, 2019, where evidence was presented. The magistrate found for the city, giving the property owner until November 14, 2019, to comply or a fine amount of $50 per violation thereafter. And there was 2 extensions given for this as well. And as of my reinspection on November 17th, 2020, this case is still not in compliance, and the city is requesting a full imposition of fines, which continues to accrue.
All right. On behalf of the owner.
Yes, sir. We applied for permits since March of 2020. We finally just got the okay on October 7th by Valerie Garland regarding the DOT permit. So this permit in particular took almost 7 months to get. Now the contractor is in the middle of getting the MOT permit, which is taking also time to get this under control. So the contractor is asking if we can get a 6-month extension on that, and all the sidewalks and everything should be up to a compliance for a given chance to get all these permits under control.
Your Honor?
Yes.
I just want to point out that the case itself is almost 2 years old, and the remaining violations that he's referring to is some areas of dead and missing grass, and there's also a sidewalk that has some cracks in it. Again, there was 2 parcels, same address, same owner, and 1 parcel was completed with the grass and the sidewalk because they both had it on both parcels, and for some reason this one wasn't completed. So the city is requesting a full imposition of fines.
Right. Okay. I'm going to grant the city's request, impose the fines, they continue to accrue.
Thank you.
Thank you.
Thank you, everybody.
Thank you. Our next case is on page 17. Inspector Will Snyder. Case number CE 18100410. Case address 608 Breakers Avenue. Owner Sebin Plaza LLC. This case was first heard on 2/7/19 to comply by 3/14/19. There are 3 suspensions notated on the agenda. 1 section complied at $100 per day. $22,000 accrued. The city is requesting full amount. Additionally, on page 18 is case number CE 18100411. Case address 600 Breakers Avenue. This case was first heard on 2/7/19 to comply by 3/14/19. There are 4 suspensions notated on the agenda. 1 section complied at $100 per day. $31,300 accrued, and the city is requesting full amount.
Good morning, Courtney. Please raise your right hand. Do you swear and affirm to speak the truth at today's hearing? Thank you.
I apologize. I do. Unmuted.
Okay, Mr. Snyder.
Yes, good morning, sir. Code Officer Snyder, City of Fort Lauderdale Community Enhancement, presenting cases CE 18100410 CE18100410 for 608 Breakers Avenue, and CE18100411 for 600 Breakers Avenue. Both cases were first heard February 7, 2019. The magistrate ruled in favor of the city, and the property owner was ordered to correct the violations at these properties by March 14, 2019. The case was next heard on May 16, 2019. The magistrate granted an extension, and the property owner was ordered to correct the violations at these properties by May 30th, 2019. This case was next heard on September 19, 2019. The magistrate granted an extension, and the property owner was ordered to correct the violations at the properties by November 7, 2019. The case was next heard on December 19, 2019. The magistrate granted an extension, and the property owner was ordered to correct the violations at these properties by January 2nd, 2020. And this case was last heard October 14, 2020. The magistrate ordered a continuance, and the property owner was ordered to appear at today's special magistrate hearing. The violation for 608 Breakers Avenue, case number CE18100410, was brought into compliance on February 10th, 2020. And the violation for 600 Breakers Avenue, case CE18100411, was brought into compliance October 14th, 2020. At this time, the city is requesting imposition of fines in the full amount.
All right, counsel.
Good morning, Your Honor. Courtney Crush on behalf of the property owner. Your Honor, we would ask that you consider a significant reduction in the fines. In terms of these properties, these are existing, it's an existing building over in the North Beach Village area of the beach. Our client went through a change of use DRC process with the Department of Sustainable Development. Actually two, from 2016 to ultimately approved the beginning of November 2018. So the uses were changed from lobby and hotel room to retail and restaurant. At that point in time, moving forward to obtain the business tax became sort of a muddy issue, which lasted for about a year. Even though renovation permits had been pulled, in May of 2019, the city did a walk around on the property, specifically the one space, which is the restaurant, and advised that additional work needed to be done. At that point in time, the business tax applications were submitted to the city, but they were on hold until this corrective work was done. The companion space, which is just a retail space, no physical construction necessary, that business tax application sat because it was all part of one building while the additional restaurant work was done. The property owner did immediately engage the contractor following the May 19, 2019 meeting, submitted for the additional work for the restaurant renovation in July of 19, and completed it in January of 2020. During that time, Your Honor, again, the companion spaces business tax where no work needed to be done just sat on a holding pattern. But it was unclear, and I believe we got different communications from the city about what, if anything, had to be done. There was discussion about a change of use building permit that ended up being moot, Your Honor, because unfortunately due to COVID, that retail space did not survive. So Inspector Snyder is sharing the compliance date on that as October, just a few weeks ago of this year. That reflects the fact that there is no business there. So again, in terms of appropriately permitting, building permit work, life safety, hoods, drainage, et cetera, all that work was first and foremost approved by the city as part of the change of use site plan, and then diligently pursued that corrective building permit action. So we think that the hold up on the business taxes, given the appropriate steps the property owner went through to obtain its entitlements, and then to supplement that per the city's direction warrants a reduction in these proposed fines.
All right, Mr. Snyder, anything further?
Yes, Your Honor. When I did speak to the Chief Building Inspector, George Oliva, Joe Pasquarello, and Victor Blanco about this case, there was a little bit of indecision about whether or not the permit was required in the first place. Ultimately, the three of them did determine that it was technically required. So I can kind of understand the respondents' plight in this situation. I think in light of that, it would be appropriate, I guess, to amend the recommendation for fines. The city would be willing to suggest a recommendation of 20% of the total accumulated fines. So for 600 Breakers Avenue, it would be $6,260. And for 608 Breakers Avenue, it would be $5,040.
All right. Okay. I'm going to follow the city's amended recommendation, $6,250 on the first case, $5,040 on the second case.
Thank you, Your Honor.
Thank you very much, Your Honor. Thank you, Inspector.
Thank you. Our next case is on page 31. Inspector Will Snyder, case number CE 19100069, case address 625 Coral Way. Owner Thomas A. Valerio. This case was first heard on 2/6/2020 to comply by 3/12/2020. There are several suspensions notated on the agenda. One section not complied with $150 per day. $6,600 is accrued and continues to accrue, and this was in order to reappear.
Okay, Mr. Snyder.
Good morning, Ryan.
Waiting for the respondent.
Good morning. Ryan Abrams on behalf of the owner, Thomas Valeria.
Please raise your right hand. Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you.
Good morning, Your Honor. Code Officer Will Snyder, City of Fort Lauderdale Community Enhancement, presenting case CE 19100069 for the property located at 625 Coral Way. This case was first heard February 6, 2020. The magistrate ruled in favor of the city, and the property owner was ordered to correct the violations at the property by March 12, 2020. This case was next heard on March 16, 2020. An extension was granted until August 13th, 2020. And this case was next heard on August 13th, 2020. An extension was granted and the property was ordered to come into compliance by August 28, 2020. This case was next heard on August 28, 2020. The magistrate granted an extension and the property owner was ordered to correct the violations at the property by September 4th, 2020. This case was last heard on October 14th, 2020. The magistrate granted an extension. The property owner was ordered to correct the violations at this property by September 19th, 2020. At this time, the violation of the property remains. The city is requesting a full imposition of fines in the amount of $6,600, which will continue to accrue.
Behalf of the owner.
Yes, good morning. So a couple things I believe are not accurate. There are no fines that have been accrued, and we're not here for a lien imposition. We're here like on a mandatory appearance, which was based on our previous request for extension. So the deadline has been extended. So, I think 2 separate times. And the reason for that is there's a dock problem. There was the citation at issue is a dock safety issue. Instead of making minor repairs to the dock, the owner has agreed to replace the entire dock. I submitted into the record a Broward County permit that has been obtained already for the environmental resource general license. An application has been submitted to the city. This is a $100,000 project. So my client is committed to resolving it, not just patching it up, but permanently. And so that's the reason for these extensions, because it's an endeavor. It's going to take some time. It's not going to be a 30-day thing. So there's no specific instruction in the court's prior orders as to what it takes to come into compliance. But we're saying we are in compliance. We've submitted permits. We are in the process of replacing the dock. So I think the reason for this reappearance the last time around, which was granted by you, your magistrate, was you just wanted to make sure that we were continuing forward, and that we are. As I said, we submitted the Broward County General Environmental Resource General License, and the application has been submitted to the city. Again, $100,000 project. It's not going to happen overnight. And fines are not accruing. Fines have not accrued. Just to correct the record, the extension means the deadline was extended, so there's no fines accruing. And here we are again seeking continue. We will reappear as often as this tribunal would like to see us reappear to update the city as to our progress. But we are making strides. We're moving forward. We expect to break ground as soon as the city issues its permit, which we hope will be within the next week.
A couple of things, Your Honor. Fines have accrued. The time period between March 12, 2020 and March 16, 2020, and also the time period between September 4th, 2020 and October 14th, 2020. As to whether or not fines can be imposed, I'm not sure what was sent out on the notice to reappear at this hearing, whether or not the attorney was notified that fines may be imposed at this hearing, but that, I guess, is something for the administrative staff or the city attorney to elaborate and clarify for the respondent.
I just want to respond. There was a mistake on 2 previous orders, which indicated fines were being imposed. That was corrected. That was not the order of this tribunal. There are no fines imposed. The deadlines were extended. So as of right now, we are in compliance. We have not violated anything. We're continuing to move forward. The deadline for compliance has been extended by this tribunal, and we are in compliance as of today.
Your Honor, they're not in compliance. The dock violation remains. The process to secure the dock repair permit or replacement permit does not absolve the violation or bring it into compliance. The dock needs to be repaired, and at this time, it's not in repair.
Okay, I'll agree that the violation may arguably still be in place, but the issue is whether the fines are accruing, is what I'm saying. As long as the deadline for compliance has been extended, fines are not accruing. That's the point I'm making.
There's periods in the time frame here where it's out of compliance, and extensions can only be granted by the magistrate.
Your Honor,
Yes.
there are no fines currently accrued on this particular case based upon the way the extensions were given. So there are currently no fines accrued.
Okay,
and also just the reason we're here today, I just want to be clear on the reason we're here today. We're only here on a reappearance on our previous extension. It was extended to today on the deadline for compliance. We think the purpose of being here is just to let you know our progress and that we're continuing to move forward. This is a dock replacement. It's not going to happen overnight, but we're moving forward. So I think it would be appropriate to, again, give us another reappearance date. We can do another 30 days, keep tabs on us. That's fine. But again, my client's spending a lot of money here, and it's gonna be a little bit, but we're moving forward. Every day, things are happening.
All right. At this point, the record shows that fines have been imposed and have accrued.
No, there's nothing else to impose.
If there's something, evidence that that's not correct or whatever, I guess we're going to have to address it once you come into compliance. But for present purposes, I'm going to impose the fines, and they continue to accrue.
There are no fines. I can't hear you.
No fine.
We're just here on a request for an extension of the compliance deadline, your magistrate. That's the reason we're here. We're not here for a fine imposition where the notice for today is only on a mandatory reappearance. And today was a deadline for compliance, but we're again seeking an extension of that deadline as we continue to pursue the permitting process. And perhaps Ms. Hassan might want to weigh in. She's been involved in this throughout the entire process.
Okay, 1 minute. Okay. So no fines have accrued.
No, sir.
Okay. All right. Apparently you're correct that no fines have accrued. But the extensions are up, correct?
Correct. And we're seeking, the idea was to continue to keep tabs on us. We were seeking another extension while we continue through the permitting process and getting the dock replaced. It's not, like I said, it doesn't happen overnight. So that's the reason for these periodic extensions, to allow us to complete the process of replacing the dock.
Question, the extension of how long?
Another 30 days.
Good morning, Your Honor. If I may speak, Supervisor Bass, in reference to this case, I've dealt with previous cases that had to go through the permitting process, even going through the county in order to get the permits for the waterway. At this time, I think that we've exalted our extensions, and at this time, the city is requesting that no further extensions be granted.
All right. Yeah, this has been going on for February. So, okay, multiple extensions. So, okay, I agree with the city's position that no further extensions are granted, but the fines will now begin to accrue for the first time.
Yes. And the property owner and the property representative can reach out to us once they're in compliance, and we will make sure that the fines are stopped once the property is brought into compliance. And then they can come back to MASI to address the fines that did accrue.
Correct. Thank you.
Thank you, Your Honor.
Thank you.
Thank you. Our next case is on page 27. For Inspector Patrice Jolly. Case number CE 20020703. Case address 1321 Northwest 7th Avenue. Owner Jason Swed. This property was cited on 8/27/2020 to comply by 9/1/2020. One section complied at $200 per day. $7,000 accrued, and the city is requesting full amount.
Good morning.
Good morning.
How are you
Jason.
guys doing today? How are you?
Please raise your right hand. We're fine, thank you. Do you swear and affirm to speak the truth at today's hearing?
Yes, I do.
Thank you. Go ahead, Jolly. Jolly, please unmute your microphone.
Okay.
Can you hear me now?
Yes, you can.
Okay. All right. Good morning, Your Honor. Inspector Patrice Jolly on behalf of the city. Case number CE 20020703, located at 1321 Northwest 7th Avenue. This property was first cited on August 27th with a civil citation for the violation 15-272.A. This property is being utilized as a vacation rental without the required certificate of compliance from the city. I was contacted by the property owner on September 1st, where the violations along with the proper corrective measures were explained. Initially, the case was thought to be complied on September 11th, but further investigation by our vacation rental enforcement administrative staff showed that from August 26th to October 7th, the property remained listed online, which the violation remained uncomplied. The property was out of compliance for a total of 35 days at $200 per day, and daily fines accrued to totaling $7,000. Contact was made with the gentleman right here, the owner property, Mr. Jason Swade, multiple times. The case was then complied on October 7th, and it's a petition of the city that the fines be imposed as read.
All right. On behalf of the owner.
Yes, hi, how you doing? So this is a property that's located in Fort Lauderdale. I currently have a couple of tenants renting it out, and from the moment that I did get notice about the violation, I immediately emailed them, and same with the other gentleman with the case that came up earlier, where they don't have control over the tenants. These tenants were supposed to stop advertising the property. I finally had to hire my attorney and threaten them for them to become compliant. I kept going back and forth with them. I must have emailed them probably about 20 or 30 times, like I uploaded. And I was always talking back and forth with Inspector Jolly. I was under the impression that Inspector Jolly was going to give us an extension due to the fact that we're working on it. And I was working with the tenants from the first day that we got the violation. And I in no way threw it on the back burner. I was on top of it the whole time. I was constantly communicating back and forth with them. It's just hard to get people to do things, especially when you can't impose evictions. And finally, when I hired my attorney to handle it, then I started getting some progress. And finally, we got it compliant and everything is okay. I mean, this property was a rundown property I purchased in the auction. I went in front of you before, Your Honor, and you've been very fair in the past. I love the city of Fort Lauderdale. I've been communicating back and forth with Inspector Jolly, and as he'll tell you, I've been doing everything in my power to get it compliant. And the fines, I can't really afford any fines right now because they already didn't pay me a couple of months of rent, and this is what I'm dealing with right now. Finally, they made a payment, but that payment went to cover back mortgage, and all I've been doing is just trying to get these people compliant, which I finally did get them to comply.
I'd like to add, like Your Honor, Mr. Swade is right. When he received the notification, he did contact me. The issue was that the tenants that are currently using the property as a vacation rental, they were lacking all the documents, the proper documents, so that they could be certified. So they couldn't even set an inspection because they didn't have all their paperwork in. And even up to into September, they were contacted by administrative staff on multiple occasions to get all their information in so that we could schedule the inspection to certify the property for vacation rentals. There are a couple
of young fellas, and I think it's a new business venture that they're doing. I have nothing to do with it. Me personally, I just rent it to them, and as soon as I found out about the violation, I was on it the whole time, emailing back and forth. I must have emailed them 25, 30 times to finally get them compliant, and even then, I had to involve my attorney, Barry Sickles, to go ahead and send them an email and basically tell them that if they don't comply, we're going to do evictions, and then we can't even evict anybody because the sheriff's office is not serving the evictions right now. So it's very hard to get rid of possession.
Okay, Mr. Jolly.
Yes,
go
sir.
ahead. I thought you were cut off. I didn't know if you were finished with comments or not.
No, I'm finished with comments because like I said, it was the tenant, but as the city attorney stated previously, that the property owner is responsible for things that happen to the property and things that the tenants do, even though he was, and I could say he was diligent in contacting me and them about getting the process done, because since they were issued the citation and he's been on them, they did actually complete and have all the paperwork that they needed to have in from February. They finally got everything together, and now the property was able to get inspected and certified.
Okay. All right. Okay. I'm going to reduce the fines to $1,500.
Your Honor, I apologize, but even as soon as I got the notice, I was in contact with Inspector Jolly, and I don't even know why I'm at the hearing right now, because I was under the impression that we got the extension, and then when I spoke to him again, he said that we were in compliant, and then now all of a sudden I got to go in front of a magistrate. I can't afford the $1,500. I'm getting ready to pay property taxes, and I haven't been getting paid the right amount of rent. And these guys I even had to pay a little bit to the attorney, which I still owe him some money to handle this for me, because I know it goes against the property itself.
Okay, Mr. Jolly, any other thoughts?
No other thoughts, Your Honor.
All right. No,
I shouldn't be charged any fines, because I was always on top of it. We're diligent. The COVID-19, I don't have to mention. It does delay a lot of things, and these people were coming up with all different excuses. They were missing paperwork. They were originally speaking with Morgan Dunn. Morgan Dunn didn't get back with them. They had a whole spiel. But the bottom line is, I've already paid. I've invested significant amounts of money into this property first, and there was a lien on the property. I do have a mortgage on it. I had to basically borrow money against the property to be able to pay the bills associated with this property. In the past, I went in front of you, and there was, I believe, a lien on it, and I already paid out about $5,000. No, I believe $7,500 to the city of Fort Lauderdale, and I honestly can't afford the $1,500 right now. I haven't been working, and it's just tough times for us. And they are in compliant now. This is the first time that I go in front of the magistrate.
all right. Okay, sir. I really think $1,500 is fair. I'm going to reduce the fine $1,000. Thank you.
Can you please make it for $500 for me?
$1,000. Thank you.
Like I said, can I just say one more thing? I should have never even been getting fined. I was always speaking with Inspector Jolly. I've been trying to contact him.
I understand. Thank you very much.
Thank you. Our next case is on page 27. Inspector Patrice Jolly, case number CE 2007072, case address 1723 North Fort Lauderdale Beach Boulevard, owner Eric and Jennifer Winston. This property was first cited on 7/21/2020 to comply by 7/27/2020. One section complied at $200 per day. $4,800 is accrued. The city is requesting full amount.
Good morning, Tim. Please raise your right hand.
Hi, good
Do
morning.
you swear and affirm to speak the truth at today's hearing?
I do.
Thank you so much.
Good morning, Your Honor. Inspector Patrice Jolly for the city of Fort Lauderdale. Case number CE 20070732. Address located at 1723 North Fort Lauderdale Beach Boulevard. This property and this case is about property violating the maximum occupancy allowed, 15-278.2B. The maximum occupancy of this property is being exceeded. Our administrative staff found that the online advertisement and online listing for the property on Airbnb showed max occupancy more than the rooms that are actually on the property. So the case was open and a citation was issued. The property was out of compliance for a total from August 21st for a total of 24 days out of compliance with the occupancy. Contact was made between the property manager and our administrative staff to get the property into compliance.
All right. The owner?
Hi, good morning, Your Honor. Yeah, I'm representing the owner. I just want to say that, the property went under new management during the pandemic. So there was kind of a difficult transitional process between the two management companies. When the city finally got in contact with us, we did comply. We haven't had any other citations previously. This was the first citation we've been given. And we just asked for any kind of leniency that you might be willing to grant us. And we apologize for the inconvenience.
Anything further, Mr. Jolly?
No, sir.
Okay, I'm going to reduce the fine to $2,400.
Okay, thank you very much.
Thank you.
Our next cases are on page 28. Case number CE 20071067, case address 2810 Northeast 60th Street, owner ES Cavell Corp. This property was first cited on 7/25/2020 to comply by 7/25/2020. One section complied at $500 per day, $5,000 accrued, and the city is requesting full amount. Additionally, on page 28 is case number CE 200-71069, case address 2810 Northeast 60th Street, owner ES Cavell Corp. Property was cited on 7/25/2020 to comply by 7/25/2020. One section complied at $200 per day, $2,000 accrued, and the city is requesting full amount.
Good morning, Ms. Grant. Please raise your right hand. Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you.
Good morning, Your Honor. Inspector Patrice Jolly for the city of Fort Lauderdale. Case number CE 2007-106. Property address 218 Northeast 60th Street. For this case, and also for CE 2007-1069, same address, 2810 Northeast 60th Street. This property was cited for this for 18-1. There was a vacation rental operating during Executive Order 20-22 at this property that is creating a public nuisance. It is being maintained in such a manner that the property is or may reasonably threaten or endanger the public health, safety, or welfare, or adversely affect and impair the economic welfare of adjacent properties. It was also cited for 15-278.2B. The maximum occupancy of the property is being exceeded. These two violations came about during the COVID-19 shutdowns back in that happened and were enacted on April 27th and throughout actually till currently now for vacation rentals. So this case and this property has been before the magistrate since, and as far as we know, it has been suspended, the license so far. For these being violations that were that accrued during the period of time frame which that we seek to have the license revoked for I think it's 180 days. So this is the hearing to impose fines. The city is requesting that the fines be imposed as read.
All right. Okay. On behalf of the owner.
Good morning, Special Magistrate. I'm not sure what's going on because as Inspector July just said that we did have a hearing for this case and I suspended the listing from that time. It's never been listed on Airbnb and no tenant has been occupying that house ever since that hearing. I can't go back into the house for Airbnb until February. And I basically suspended my account from the time of the hearing. And since then, no one has been residing there at all. In addition, with the maximum occupancy, he told me to come into compliance by changing, this was previously before we had that hearing that I'm suspended now, to change occupancy to 10 people, which I did on Airbnb. And I sent him the actual updated picture of that back. I can tell you the date right now when I sent it to him, and he should have confirmation of that as well on his end. That was sent to him on August 7th, 2020, that the property was in compliance for the occupancy going down to 10 people on the actual listing. No one has been living in my house since then. It's just been since, I think, just this past week, my realtor called me and said he had a potential leasee to go and lease the property out from me. So now I'm going to lease my house out the normal way as an actual regular lease, standard lease, residential lease, not by Airbnb anymore. So I'm asking Your Honor to please do not fine me, since I've been in compliance since the very first time that Inspector Jolly told me about this thing. I delisted the property on Airbnb. I've not taken any more phone calls from anyone because the property's not even listed. So no one's even contacting me at all. And immediately I changed everything on Airbnb initially to 10 people. Since then, the property has been vacant. And thank God, just now I have a prospective tenant who's going to move in soon as a residential leasee. Yeah, it's a husband, wife, it's a family.
Okay, just wanted to just so the clarification. These violations and the fines that accrued were prior to the day she's saying of August 7th when she changed the listings. These were from the 5th, and they were complied on August 5th, and they were issued in July. So these were the days that she was out of compliance for that time frame before we had the first initial hearing where they suspended her her license. So that's what this is for. This is prior to that. This is not anything to do with after the license was suspended. This is before the license got suspended.
So why was this addressed from the first hearing? Why wasn't I aware that I was going to have fines to pay? Why is it just now, like months after, almost August, September, October, November, 4 months later, I'm now hearing that I have to pay fines of $5,000 and $2,000. I don't have that kind of money. I'm a state attorney. I work in Miami as an assistant state attorney, and the government, I'm sure you guys know, we don't get paid very well. So I can't afford to pay fines.
Your Honor, if I could, Ronald Montoya Hassan with the City Attorney's Office. If counsel is an attorney, then she should have read. These are citations. Citations have they're in a slightly different posture. Citations have an appeal time that are stated on the actual citation themselves. And as Your Honor notes on the agenda, the appeal deadline for both of these cases was August 9th. So the ability for the property owner to contest the citations was extinguished because there was no appeal filed. So for the citations, the only issue now before the special magistrate is the imposition of fines and perhaps the mitigation of that fine on both of the citations to some different amount. If the property owner discusses some sort of extenuating circumstances or mitigating factors, but by the process of the citations, they were not appealed, so they are valid citations, and now the only issue is the imposition of the fine, Your Honor.
Ma'am, did the owner want to add any other comments?
Your Honor, I'd just be asking for mercy right now at this point, since you have to impose a fine. I'd be asking for you to please, take in consideration that because of the virus, we've been working from home, number one. In addition to that, I had to go on maternity leave. I just had a baby. My baby is just 3 months old, and I just now started back work recently. I went back to work October 30th, so I'm not in a position financially to take care of any fines at this moment. So I'd be asking for Your Honor to just have mercy and impose something way less, please.
All right. Well, you were 10 days. Okay. 10 days there. Okay, all factors considered. On each case, I'm going to reduce the fine to $1,000 each case. Thank you.
Thank you, Your Honor.
Thank you.
And I have a quick question, ma'am. I'm not sure if you can assist me, but I was also cited a fine the last hearing of $900. I'm not sure if that's including with these $2,000. Is that correct?
I don't know about another case.
It's the same case, Your Honor, but they had given me a fine as well for 900 and something that I was ordered to pay. And I think Inspector Jolly should have notes on that as well.
Counsel, it can't be the same case because these are two different citations. So what's before the magistrate today is not even one case. It's two cases and they're citations. So the other one's going to be a different.
Inspector Jolly, do you have any information on that or no?
Excuse me?
Do you have any information on the last time? I mean, the last hearing was for what, just a suspension?
The last hearing was for suspension.
Yes.
And there was also fines that accrued from a different citation where the judge reduced that fine as well to $900, which is separate.
Okay, all right, thank you very much. So it's 2009 altogether. All right, thank you. Thank you, Your Honor.
Okay, thank you.
Thank you.
We are recalling the case on page 17 with Inspector Gail Williams.
16.
Case number CE 19071855, case address 521 Southwest 10th Street, owner Sabrina and Azim Visram. This was the city's request to vacate the order of 9/23/2020 and rehear the case. There was documentation that was going to be provided regarding an arborist letter. From my understanding from the supervisors in the office, the letter has been received and they would like to rehear the case at this time.
Good morning, Your Honor. Gail Williams for the City of Fort Lauderdale, presenting the case. I was able to locate the arborist letter in reference to that was sent to the landscaping department. And according to the report / letter, the arborist did state the statute of the 163.045, deeming the tree removal based on a dangerous tree and next to and above a 2-story building. And the roots of the foundation of the tree is at high risk due to the bark. So therefore, based on this letter and review with one of our landscapers here in the office, the case and the tree is, the arborist letter is okay based on the permitting not being needed to remove the tree. So at this present time, the city is requesting administrative cost of $626.
Okay. Owner on the line.
Hi,
Yeah.
this is Omar Gerald on behalf of Sabrina Visram. I would just per my reading of the Florida statute, this entire process was unnecessary. But if there's any statutory authority or city ordinances that award the city the administrative costs in light of there being no permit necessitated due to the arborist letter, I'll defer to you, special magistrate. But per my reading of the statute, and then I would also just ask, depending on when those administrative costs are being accrued, because the email correspondence that I forwarded to Ms. Williams was from the landscape inspector, Christy McCullough, dated March 24th of 2020, stating, "Hi, Hector, I've read the report, verified the arborist credentials. This will be sufficient to close the case per Florida Senate Statute, section 163.045. Ms. Williams was CC'd on that back in March of 2020. So, and these were all emails that were sent to my client. On there, it said, "I will add the report to our records and inform the code officer to close the case." So I think that I don't know what costs and when they were incurred. My client thought that this case was completely closed based on the correspondence by the city. So, I'll defer to if there's authority to grant those administrative costs, I defer to the magistrate. But that's where this entire issue stemmed from. It was always our understanding and her understanding that this case was closed way back when. And we're on where the procedures are going forward.
Excuse me, Your Honor. This case was open in November 7th,
2019. And this arborist letter wasn't received until March 2020.
No, and I stated that I agree. The email from your office was received March 24th of 2020. So if there's going to be a cost imposed, obviously we're here and there were hearings subsequent to that email. So I'm just trying to ascertain when those administrative costs are being imposed from. Like, obviously anything from that date forward, there should be no costs. Anything prior to that, okay, I would understand since you didn't receive the letter. So that's just the clarification I'm trying to receive. I'm not saying that you received the letter any earlier than that, because that's when the email was sent to the city.
All right. Thank you, Counselor. Thank you on behalf of the city. I'm going to impose administrative cost $626.
Okay, thank you, Your Honor.
Thank you.
Our next case is on page 16, Inspector James Fetter, case number CE 20050773, case address 412 Southeast 32nd Street, owner 3131 Southeast 6th Avenue, LLC. This property was cited on 5/30/2020 to comply by 5/31/2020. One section complied at $250 per day, $6,500 accrued. The city is requesting full amount.
Yes, James Fetter for the City of Fort Lauderdale Code Compliance Office. This is case CE 20050773. Address.
James. 1 minute, please. Thank you. Mr. Thomas, please raise your right hand.
Oh, sorry.
Do you swear and affirm to speak the truth at today's hearing?
Yes. Can you see me?
I can. Yes, we can.
I'm new at this. I don't even know if I'm doing it right.
You are. Go ahead, James.
Address 412 Southeast 32nd Street. This is for the tenant Bimini Bay Bar. And the property was cited for 18-1. There is a violation of the emergency order 2012. There's a bar, nightclub, and should remain closed at this property that is creating a public nuisance. It is being maintained in such a manner that the property may or reasonably become infested with inhabited rodents, vermin, and animals, or may furnish breeding place for mosquitoes, or threatens and endangers public health, safety, welfare, or may adversely affect the impact of the economic welfare of adjacent properties. I issued a warning citation on 5/30 with a reinspection date on 6/20 of 2020, and they were still remained open. I went back on 6/27 when we got an order that we were able to close businesses for not complying with the emergency order of 2012. And I requested that they either close or I would have the police come on and close them. And they did close that day. And there's a fine of $6,500 that accrued during that time.
Okay. On behalf of the owner.
Yeah, I don't have any idea what he just said. All I got is a thing here for $250 because restaurants were allowed to open. I've been told by the city and the county for 13 years that I am a restaurant, even though I'm not. So when it behooved me to be a restaurant, I added food, I added tables, I added all the restriction stuff that they said to add. And I reopened temporarily as a restaurant. There's no rodents, there's no insects. I lease 20% of this building. The other 80% has been empty for years. Okay, I don't know where he's getting all this from because he's never said it to me. All he ever said to me was, you're not a restaurant, you have to close. So if I'm not a restaurant, why am I paying $472 a year for 13 years for a food hygiene permit from the county, a city restaurant tax license, and All these years, they've been telling me, you're a restaurant, cost of doing business, sir, and they hang up. So now they open restaurants, so I open, and I have food, and I have the tables, and I have the masks, and the shields, and the hand sanitizer, and everything they said to do. The social distancing, the 50%. And I argue with them, I am a restaurant. I've been told that by your boss. And they come and they give me a summons for $250. So threatened to have me arrested, so I closed. So basically, I've been closed since March till September. Never heard a thing about $6,000. And why would I get charged anything for a misunderstanding? First of all. Second of all, these licenses all expired at the end of September, and I had to renew them all at full price. Not prorated because we were closed for 6 months, but full price. I don't think I did anything wrong, except stand up for my rights, because I've been told by the city and the county that I'm a restaurant for 13 years. And then this inspector comes and says, no, you're not. Maybe you are, maybe you're not. Then he comes back and says, no, my boss says you're not. I don't know where these fines are coming from, but I can't afford it. I just spent 6 months paying bills on a place that's closed. This is a misunderstanding. There is no rodents. I don't know why he's saying
Sir, no
that.
one's mentioning rodents. No one's mentioning.
He just did.
No, he did
Jim
not.
just did.
That was just part of the section that was uploaded from the normal program.
It's part of the
emergency
whole
the
thing.
emergency order 2012 section 2A states bars, restaurant, nightclubs must remain closed until the order is lifted. And I believe this business has less than 50% of their revenue is created from food, which I believe then that would qualify them as a restaurant to be able to be open during the pandemic. And when I asked him how much sales of food he had, he said he sells hot dogs and peanut butter and jelly sandwiches for $1. And I believe that he sells probably much more beer and wine than that.
That's correct. I was just trying to comply with the.
So that means that you should not be open until, I believe, the emergency order opened the bars on October 1st. So
this should've
when I
to the
went in there on
magistrate
May 30th,
before the
when I
fine.
went in there on May 30th, you were open as depicted in my photographs. I went back on June 2nd and you were still open, depicted in the photographs. And then on June 27th, I went there and the bartender and the other gentleman that was there, they closed the business and posted the sign closed by the government, which complied the violation.
And Your
That's
Honor, if
how
I
you
could-
have $250 per day while you were open the whole time until you closed on the 27th. And I did explain that all to you, and I explained to you that you can come, you can request a hearing and come to and explain that to the magistrate that you felt like you were a restaurant, which I don't see any cooking facilities in the bar. And it is called Bimini Bay Bar, so it's not called Bimini Bay Restaurant and Bar. So I feel like it was a bar.
It is a bar. I've been saying it's a bar, but why have I been paying and being told by the same people that are trying to fine me $6,000 for 13 years that no, I'm a restaurant and that's the cost of doing business, sir.
The business tax department is a different department than
full price
our department.
Sir,
instead of
let the
prorated.
inspector speak.
The business tax department is a completely different department than the code department. You would have to take that up with them as to why you're required to have that license.
Your Honor, if I could, Rhonda
Yes,
Montoya
please.
Hassan.
I was about to ask for your help.
Yes, Thank you, Your Honor, with the city attorney's office. Again, Your Honor, just like the last case, this comes to the magistrate in the posture of a citation. The issue of the substance of the violation, i.e., did the business violate the order, is basically already res judicata by the terms of the citation. As the agenda notes, the appeal deadline to appeal the validity of the citation was June the 14th, 2020. And the code specifically provides that if citations are not approved within the time frame listed on the citation by the property owner, they are deemed a violation. And again, just like the last case, really the only thing we're here on is the imposition of fines. So, you know, if Your Honor and if the property owner wants to, you know, detail any hardship or issue with regard to the amount of the fine, obviously it's within Your Honor's purview to address the amount of the imposition. But in terms of the substance of the violation, you know, we're going back and forth and upside down and sideways. It's already been determined by the lack of an appeal for the citation.
All right, okay.
If you notice, Your Honor, every picture he has, there's no customers there. So how open were we? There was no customers there. We weren't allowed to
There's
have
a customer.
There's my manager in there cleaning the place, and that's about it. We had to close by 10 o'clock. There's nobody in there till 10 o'clock.
Sir, did you not listen to what I just said? What I just said was you did not appeal the citation timely, which was by June 14th. Right now, the only issue before the magistrate is the imposition of the fines and the amount of that fine, which
And I
the
did not
magistrate
appeal
has
because
the
I'm
authority
not
to
an
reduce.
attorney, and I cannot afford an attorney. Very easy for you to say I did not appeal, but you need an attorney to appeal correctly, and I can't afford one because I've been out of business since March.
No, you don't. All you have to do is write a letter or an email to the magistrate saying you contest the violation. People do
No,
it every
I do not
day,
know.
every month.
Right.
And I would like to point out that
I
would like to point out that
one
there
thing.
are
Governor,
Yes, let the inspector speak.
there are customers in this photograph, and then also on the June 2nd photograph, there was only one customer there, but they were open. So, or else I wouldn't have been able to enter the business.
Listen, I know what this man told me. I also know what the president said, what the governor said, what the mayor of Broward said, what the mayor of Fort Lauderdale said. They all contradicted each other. And I'm sitting there losing my shirt trying to figure out who I listen to. So I took a shot. I have 2 licenses for a food hygiene permit and a restaurant tax license. And I said, yes, it's time to open as a restaurant. Let's try that. Okay? Because of the contradictions from the federal government and the governor and the county and the city, all changing the rules daily and all contradicting each other to this day. I shouldn't be fined anything for the incompetence of all these governments put together.
All right, I'm ready to rule. I'm going to impose a fine of $3,000. Thank you.
Our next case is on page 6. Inspector Gustavo Caracas, case number CE 20021037, case address 304 Southwest 11th Street, owner Mary Beth Nielsen. Property was posted 10/29/2020, posted at City Hall 11/5/2020.
Can we go to the next case, Katrina? We'll come back to Gus.
Our next case is on page 18. Inspector Will Snyder. Case number CE 180300099. Case address 1447 Northwest 6th Street, owner Larry G. James. Case was first heard on 12/5/19 to comply by 1/16/2020. Suspended 3/5/2020 to 3/19/2020. One section complied at $50 per day, $2,050 accrued, and the city is requesting full amount.
Good morning, Elise. Please raise your right hand. Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you.
Good morning, Your Honor. Code Officer Will Snyder, City of Fort Lauderdale Community Enhancement, presenting case CE 180300099 for the property located at 1447 Northwest 6th Street. Case was first heard December 5th, 2019. The magistrate ruled in favor of the city, and the property owner was ordered to correct the violations at this property by January 16, 2020. Case was next heard March 5th, 2020. The magistrate granted an extension, and the property owner was ordered to correct the violations at the property by March 19, 2020. The violation at this property was brought into compliance on March 12, 2020. The city is requesting the full imposition of fines in the amount of $2,050.
On behalf of the owner,
Hi, Elise Lemstrom on behalf of Larry James. I'm sure everyone is familiar with this property. A restaurateur rents it from the owner. It's Sea City Chicken and Seafood right on Sistrunk. We have been in talks with the CRA. The James family owns the old taxi cab stand that's right next door as well. We've been in talks with the CRA for a couple of years now, trying to figure out a plan, since that is such an integral part of Sistrunk. The sign specifically is the original Champburger's sign, which is part of Fort Lauderdale history. So when we first received the citation, we went back to the CRA and we came back to code enforcement and said, what do you guys want us to do? Because we were being asked to restore the sign, but not given specifications. And we've been working with a sign restoration company. Anyhow, long story short, the sign where it stood, it was not up to current code as far as where it's placed on the property, but was a historic landmark. So there were several issues. We hired a sign restoration company to remove the sign, and we have been paying for them to store the sign ever since, so that it can eventually be restored and brought back to the property. Complete honesty here, I had no idea that since we had received approval for the extensions, that we were incurring any fines. So just in the last couple of days and being notified of this hearing is the first time that I was aware that this is incurring fines. And we are just asking the city to be as lenient as possible, because we are trying to bring this historic landmark back. But also, since it was deemed, I'm not sure if it was said to be a nuisance, it was rusty. So the city was saying that it's not safe, which we completely understand. But we are also now paying to store this sign so that part of history doesn't just disappear in the meantime. So we are trying to do our best and trying to do our part to bring that historic site back. So again, we would just ask that you work with us here as best possible, so that we're not continuing to move in the wrong direction and paying fines instead of putting that money towards restoring that very integral part of Sistrunk.
Mr. Snyder, anything further?
Just a couple of things, Your Honor. It is actually pretty interesting. The sign was, I guess this property was owned by Muhammad Ali, which I thought was really cool during my research, and it is a historical landmark in the city of Fort Lauderdale. Unfortunately, there's really not much in the way of requesting reduction to the administrative costs. So many inspections have been conducted on this case. The administrative cost is $1,905. Anything beyond that would be at Your Honor's discretion.
Administrative cost, or how much?
$1,905. There was a lot of inspections conducted by the previous code officer assigned to this case. I can't speak as to why. But there was a lot of research that needed to be done here just in the building division, because originally there was a violation that probably shouldn't have been there. And it did take a lot of diligence in locating the permit for the sign in the first place. So that could be a reason. But as it stands, the inspection total and hearing total administrative cost is $1,905.
And I don't mean to interrupt, but I just want to say I do appreciate Officer Snyder. When he first came onto this case, we spoke at length, and he did do his due diligence and research into this, because it was confusing to us. We were being told to keep the sign, to restore the sign. No, you can't. You need to take it down. It needs to be done right away. And, you know, I'm not sure why previous to Mr. Snyder, there were so many inspections that we weren't even aware of. But I think Mr. Snyder would agree that as soon as he came on board and explained to us what needed to be done, we jumped right on it and did what we could as quickly as possible. And I think, again, that some of those administrative fees, it sounds like, is due to the city going back in their records and finding what was originally done, again, by Muhammad Ali, which is why it's a historic landmark. But that was records that needed to be pulled that were long before this family owned the building. And the family really does just want to do their best to not destroy something that is such a cool part of downtown. You know?
Ma'am, let me ask you a question. What kind of establishment is this?
It's a restaurant. It's a takeaway restaurant. It was originally Champ Burgers. Muhammad Ali opened a couple of burger restaurants back in the day. And this was one of the first ones that he ever opened. So it has, or it had, and we're now storing the sign, that this huge standalone sign down towards the road that was in the shape of a burger and has a big arrow that has these cool light up features and all kinds of stuff that it's technology that's no longer used. So finding a sign company that could bring that back to life was quite an adventure as it is. But getting someone that could take down such a massive steel structure safely was also a bit of a task. But we do look forward to getting it back to where it should be.
Okay, all right. I'm going to reduce the fines to $1,000. Thank you.
Thank you very much. We appreciate it.
Good luck.
Our next case is on page 6. Inspector Gustavo Caracas, case number CE 200211037, case address 304 Southwest 11th Street, owner Mary Beth Nilsson, property posted 10/29/2020, posted at City Hall 11/5/2020.
Good morning, Mary. Please raise your right hand. Do you swear and affirm to speak the truth at today's hearing?
Yes.
Thank you.
Good morning, Your Honor. Inspector Caracas of the City of Fort Lauderdale Code Compliance Inspector, presenting case numbers Charlie Echo 2002-1037 for the property located at 304 Southwest 11th Street. Inspections of the property were performed on March 1st, 2020 and cited for the following violations. The 9-305B, the landscape at this property is not maintained in a neat and well-kept appearance. There are areas of dead and missing ground cover, including but not limited to the swale and the right-of-way. 9-304B, complied. 47-34.4.B.1. There's overnight parking of trailers, boat trailers, recreational vehicles, commercial vehicles, mobile home, bus, inoperable vehicles, and/or watercrafts improperly parked or stored at this property. 9-306 has complied. 18-12A, there's overgrowth, trash, rubbish, and debris on the property and on its swale. 18-4C, there's a derelict vehicle or trailer on the swale or on the property. Courtesy notice was issued and to the owner of the property to come into compliance, and was actually posted on the property. And also a notice was mailed to the property owner as listed on BCPA the same day, allowing 10 days to come into compliance for the property. Contact has been made with the property owner, and also we've been explaining how to come into compliance. Final notice was mailed to the property owner on March 31st of 2020. A pre-hearing inspection was done on November 16th of 2020, and the pictures presented here were taken to confirm the violations still exist. The city is requesting the following, Your Honor. For 9-305B, 35 days. For 47-34.4.B.1. 35 days. 18-12A, 10 days. And 18-4C, 10 days. I believe the owner is with us today, and she would like to speak today, sir.
Okay, I'm not sure what you decided for the swale. I had a prior case with Linda Holloway where she made me put gravel on my swale. So is that okay now?
No, ma'am. Your Honor, there was a prior case, and I have spoken to Senior Officer Linda Holloway in regards to that. And Linda Holloway, at some point, she was using her grass or the green area to park her vehicles. So it was actually suggested to put an extension of small gravel, but what she did is she extended the whole right-of-way to put gravel. And she used to have live ground cover there. So the answer is no, ma'am. You actually have to put ground cover there, ma'am.
Okay, but when I purchased the property, that was parking. There was never grass there. I only purchased this property in 2008. So I looked at the pictures that you suggested, and in 2008 it was gravel. It's always been gravel.
No, that was actually missing ground cover, ma'am. And it was up to you as the property owner to maintain the swale.
But I have the photographs of the gravel. Somebody had already put gravel there. And then she told me to go ahead and put more gravel, and she actually passed that. And she said I was in compliance when I did the gravel.
Unfortunately, ma'am, at this time, you are not in compliance. You do require ground cover where ground cover is needed, which is your swale, ma'am.
I know, but why would I pay for this again and be in compliance once and now not in compliance?
Ma'am, let me speak. If you wish to maintain what you have there existing, I will suggest you come to the building department, to the zoning department, and request for you to have that gravel on the swale.
But she made me in compliance by doing that, so I don't understand.
I have no record, no idea what you talked to her about, but at this time you do have a violation now.
Landing strips. Okay, are they allowed to have parking, the strips of parking with just the concrete and then grass in between?
You're required to have live ground cover on the swale, ma'am.
But they cannot have the pavers in the middle of the grass? Strips. 2 landing strips, like 2 driving strips?
You require to have live ground cover on the swale.
But that would include the grass. That would include more than half grass.
Again,
I'm just saying because my neighbors have the exact same thing, and that's why Linda said it was okay, because the neighbors, she actually pointed out the neighbors and showed me that I needed to add more gravel because I didn't have enough gravel.
So I just, Supervisor Stephanie Bass for the city, I just want to intervene to say that as the inspector has already indicated, any type of alterations to the city swale area, which is the city right of way, has to have an approval and a variance approval for you to alter the city right of way in any type of shape, or form. As far as your overall property, at least 40% of that property should be live ground cover. So if you have you don't have the required amount of live ground cover, you have to ensure that you do according to the city ordinance. So at this time, what we're asking you to do is to ensure that the right of way has the required live ground cover that it's supposed to have. If you're trying to alter that in any way, we're going to ask that you request a variance to alter the city right of way in any manner.
Yeah, no, I didn't even want to do it at the time when Linda suggested it, but she pointed out how the other people had done it in the same manner in my area. So you're saying 40% of the swale or 40% of the whole front?
No, 40% of your entire property should have live ground cover. That's right of way is not your property. The right of way is the city's property, actually, but you're required to maintain that in conjunction with anything that's adjacent to your property. And that area needs to have live ground cover. So we're not talking about just the swale. Any other percentage of your property should have at least 40% of the ground cover. As far as the gravel that you're referring to for its parking purposes, if the inspector may have suggested maybe it was a little, your vehicle may have been protruding out a little bit on a area that was live ground cover. And since you can't park on live ground cover, she was probably suggesting that you put it on some type of hard dustless surface to ensure that you're in compliance with what the city ordinance states. So again, what we're requiring is for the swale area to have the live ground cover. It's needed for the purposes of the soil maintenance as far as when it rains and things of that sort. We want to make sure that that live ground cover is soaking up any type of extra rainwater or any type of moisture so that it doesn't cause flooding in the streets or anything of that sort. So again, for any type of alterations on the swale, we're asking that you get a variance on your property. Any vehicle that you have on the property should be parked on a hard dustless surface. And what I'm explaining is that the hard dustless surface should not exceed more than 40% of your expected live ground cover on the property.
Okay.
Okay. Thanks.
Thank you. Your Honor.
I heard time, 35 days on the first two, 10 days on the second two, or how much?
Yes, Your Honor.
Which ones are 10 days?
The city is requesting again, what you said, or a daily fine of $50 for each of the violations that exist.
Okay. All right.
Which violations are 10 days, which are 35?
The violations, 35 days are the swale, the live ground cover. The trailers have to be removed. All trailers have to be removed. And 10 days for the miscellaneous trash that we spoke about, where you have the fire hydrants that's inside your property, and the derelict vehicle that's still in the property. And we're talking about the one that doesn't have a tag, the Mercedes that we spoke about now.
Okay. Yeah, but the camper is allowed. I thought the camper is allowed. If you have a licensed camper, you're allowed to have it there.
Ma'am, like I said before, you have somebody living in the camper.
No one's living in there now. That guy passed away. There was only a person slept in there, but no one's living in the camper.
You have it attached to the house. There's electricity running from the house.
Yeah, they disconnected everything. They took out all the trash. The vehicle can be taken care of. Everything except the swale. Yeah, I mean that can be.
Here's the thing. I
re-inspected probably in a week. I can get all that taken care of.
The issue again, ma'am, is that you've had this for many, many years. You've had probably half a dozen campers there, and you had people living in there. If you're gonna have a compliance, I'll be more than glad to re-inspect, but nobody has to be living in the camper, and the camper has to be for recreational purposes only, which means you drive it out and nobody living in there, not attached to the house or nothing of that nature.
Okay.
All right.
Now, in the vehicle itself, the trailer does have a tag, I'm assuming, correct?
Yes.
And it is registered as we speak, up to date.
Yes, it's registered to this address.
Okay.
And the title's in my name.
Well within the property, yes. Okay.
Okay.
And then I will make sure that the rest of we'll take care of the swale this week.
I'm giving you 35 days. You can take 35 days, ma'am.
Okay. No, I mean, just the sooner the
Ma'am,
better.
The sooner
Ma'am,
the better.
you'll get a written order in the mail.
Thank you.
Thank you, Your Honor.
Okay, thank you.
That concludes our respondents, and now we'll begin with our non-respondents. Would you like to take a break, Magistrate, or continue?
Which page?
With the Magistrate, like a break, or shall we continue? Our next case is on page 3. Inspector Vaughn Malakias, case number CE 20071366, case address 2656 Middle River Drive. Owner Robert D. Albanese, property posted 11/2/2020, posted at City Hall 11/5/2020.
Can I take my mask off?
Yeah, you can.
Okay. Where was the mute? I didn't look.
I wanted to see the pictures.
Okay. Good morning, Your Honor. Leonard Champagne for case CE 2007-1366 at 2656 Middle River Drive. I'm presenting this for Vaughn Malakias. Okay. This property was first inspected on August 1st, 2020 for 3 violations. 2 of the violations, 1812A and 9304B, have been complied. The remaining violation is for 9306. The front glass window is found broken and in disrepair. Those are sections covered with tape. Okay, the last inspection was done on November 16th, 2020. That violation remains. The city is requesting allowing 14 days to come in compliance or $50 a day thereafter.
All right, the owner.
Next case is on page 4.
Page,
Oh.
page 3, top of 3, right?
I find the violation does exist, 14 days to comply, $50 per day thereafter.
Thank you, Your Honor.
Thank you.
Next case is on page 4, case number CE 201-00234. Will Snyder is the inspector.
I'm not hearing her at all.
I'm on.
Get closer.
Next case is on page 4. No?
I'm sorry, could you repeat? Are we on page 4 with Will Snyder, or we had another Q? Are we on page 3? Which page?
Okay. Next case is on page 4. Will Snyder is the inspector. Case number CE 201-00234. Address 319 7 Isles Drive. Owner Little Tiger 4 LLC.
Mary, could you go to the next case, please? Other than that, because we evidently have a mix-up with the queue.
Okay, it's on page 5.
Oh, I'm sorry, disregard. He's here. We can continue.
Thanks, Stephanie.
My apologies.
No problem.
Did the respondent already?
There's no respondent.
Oh, I'm just reading it in. Okay. Code Officer Will Snyder, City of Fort Lauderdale Community Enhancement, presenting case CE 201-00234 for the property located at 319 7 Isles Drive. The property was first inspected October 7, 2020, and given 30 days to correct for the following violations. 18-12A, overgrowth, trash, and debris, which has since been brought into compliance. 9-308B, the roof at this property is stained with mildew and requires cleaning. And 8-91C, the dock is in disrepair at the rear of this property, and this condition is found to be unsafe and unsatisfactory. The city is requesting 63 days to correct the 2 remaining violations, or a fine of $50 per violation for each day thereafter.
All right, the city's request is granted.
Thank you. I'll submit my evidence to the case file.
Next case is on page 5. Gustavo Caracas is the inspector. Case number CE-19111014. Address 700 East Dayton Circle. Property owner Jean Robert Parent. The case was notice was posted on the property 10/29/2020, posted at City Hall 11/5/2020.
Mary, the inspector had to excuse for a restroom break for a second. So could you please go to the next inspector,
Okay.
please? Thank you.
Next case is on page 7. Oh, he's the same one too. Next case is on page 8. Michael Jordan, the inspector, case number CE 20040420, address 3167 Northwest 68th Street. Owner Helen M. Levitt Estate.
Good afternoon, Your Honor. Officer Michael Jordan for the City of Fort Lauderdale, Department of Sustainable Development, Code Compliance Division.
Sorry, say that again. Repeat what you just said.
Good afternoon, Your Honor. Officer Michael Jordan for the City of Fort Lauderdale, Department of Sustainable Development, Code Compliance Division.
If there's anything with this schedule, withdraw it. Sorry, Michael, we have to withdraw this case because we have no service.
Very well.
Is Gus back?
Yes, he is. Yes, he is, Mary. You can go ahead with that case, please.
That's page 5, case number CE 19111014, address 700 East Dayton Circle. Property owner Jean Robert Parent. Was posted at the property 10/29/2020, posted at City Hall 11/5/2020. Gus?
Good morning, Your Honor. Gus Caracas, City of Fort Lauderdale Code Compliance Inspector, presenting case number CE 191111014 for the property located at 700 East Dayton Circle. Inspection of the property was performed on January 1st of 2020 and cited for the following violations. 9-305B, complied. 9-304B, complied. 18-1, there's outdoor storage of personal goods and materials on the carport area at this property that is creating a public nuisance. It is being maintained in such a manner that the property is or may reasonably become infested or inhabited by rodents, vermin, or wild animals, or may furnish a breeding place for mosquitoes, or threatens or endangers the public health, safety, or welfare, or may adversely affect or impair the economic welfare of the adjacent properties. 47-34.4.B.1, there's overnight parking of commercial vehicles and or watercrafts at this location. 9-306, the exterior building walls have not been maintained. Structural parts, including fascia and soffits, are in disrepair. There are areas of the exterior that have stains and missing peeling paint. Courtesy notice was posted to the property, giving the property owner 10 days to come into compliance on the same day. Officer has made contact with the property owner and has spoken to the property owner and how to come into compliance, as well as other officers and inspectors have spoken to him on how to come into compliance. Final notice was mailed to the property owner on March 3rd of 2020. An appear hearing inspection was done on November 16 of this year. And the pictures presented here were taken to confirm the violations still exist. The city is requesting 35 days to come into compliance or a daily fine of $50 for each of the violations that exist.
Find that each violation does exist. 35 days to comply, $50 per day thereafter.
Thank you, sir.
Number CE 20060315. Gustavo is the inspector. Case address 501 Southeast 21st Street. Owner SFR 2012-1 Florida LLC. posted at the property 10/29/2020, posted at City Hall 11/5/2020.
Good morning, Your Honor. Gus Caracas for the City of Fort Lauderdale, Code Compliance Inspector, presenting case number CE 200-60315 for the property located at 501 Southeast 21st Street. Inspection of the property was performed on June 8th of 2020 and cited for the following violations.
Okay.
9-308A, the roof is not in good repair and is not weather or watertight. 9-280B, there are building parts which are deteriorated and not maintained, including but not limited to the ceiling throughout the dwelling unit. 9-280G, there are electrical wires and accessories not maintained in a good, safe working condition, including but not limited to wires exposed in the attic where damage was done in the kitchen area. 18-1, there are termites and rats in the attic of this property that is creating a public nuisance. It is being maintained in such a manner that the property is or may reasonably become infested or inhabited by rodents, vermin, or wild animals, or may furnish a breeding place for mosquitoes or threatens or endangers the public health, safety, or welfare, or may adversely affect and impair the economic welfare of adjacent properties. This is a public nuisance that it may threaten or endanger the health, safety, and welfare of the occupants, or may reasonably cause diseases. A courtesy notice was issued and also mailed to the property owner, or to the, in this case, will be the representative of the property owner, on June 8th, allowing 30 days to come into compliance. Contact has been made with the property representative. And I've explained to the lady of how to come into compliance. As of today, sir, I have not received or any phone calls, emails, or anything in regards to this property. Final notice mailed on the property to the property on August 11th, 2020. Pre-hearing inspection was done on the exterior of the property on November 16th of 2020. And again, as of today, sir, I don't know if the property has come into compliance or not. The property itself is actually unoccupied. The city's requesting 35 days to come into compliance, or a daily fine of $50 for each of the violations that exists.
I find that each of the violations does exist, 35 days to comply, $50 per day thereafter.
Thank you, Your Honor.
Thank you.
Our next case is on page 8, Inspector Michael Jordan. Case number CE 200404020, case address 3167 Northwest 68th Street.
Katrina, it's been withdrawn.
I'm sorry?
It's been withdrawn. 3167. Thank you.
On page 8, case number CE 200404020 has been withdrawn. Our next case is on page 10, Inspector Mike Sanguinetti. Case number CE 200900574, case address 1041 Southwest 29th Street, owner Mary Knight, estate. Property posted 10/19/2020, posted at City Hall 11/5/2020.
Hello, Code Enforcement Supervisor Reggie White, presenting case for Inspector Mike Sanguinetti. A routine inspection was conducted at this unoccupied single-family residence, Zone RD 15, on September 15, 2020. Found several minimum housing standards violations. 9-306, the exterior building walls have not been maintained. Structural parts, including fascia, soffits, are in disrepair. There are areas of the exterior building walls that have stains and missing peeling paint. 9-308B, there is debris, trash, or other elements on the roof, which is not permanent part of the structure. Section 9-313A, property is not identified by an approved address. And finally, section 18-12A, there is overgrowth, trash, rubbish, and debris on this property and swell. An inspection report was posted on the property on September 15, 2020, and copy mailed to property owner as listed on Broward Property Appraisers, allowing 10 days for the overgrowth, trash, and debris, and 21 days for the other violations to be corrected. A pre-hearing inspection was conducted on November 16, 2020, showing that all violations remain. The city is requesting that the property be brought into compliance within 10 days for the overgrowth, trash, and debris, and 21 days for all other violations to be corrected, or a fine of $50 per day for each violation thereafter to be imposed. I would like to submit the photo evidence to the court.
Very good. City's request is granted.
Our next case is on page 11, Captain Robert Kasarwich. Case number FC 200600013, case address 2400 North Federal Highway. Owner Antweiler JJJ Revocable Trust, Robert Rickle trustee in care of Edens and all others. Property posted 11/2/2020, posted at City Hall 11/5/2020.
Good afternoon, Your Honor. Captain Robert Kasarwich, Fort Lauderdale Fire Marshal's Office. Case FC 200600013. Property address 2400 North Federal Highway. Property was cited in reference to NFPA 150.5.2.1. That violation is complied. NFPA 150.5.6.1. That violation is complied. NFPA 113.3.1.1. That violation is complied. NFPA 113.6.4.3.2.1. The fire extinguishers have not been serviced and tagged by a certified person or company within the past 12 months. These violations were last noted on Tuesday in suites 2426 and 2362. Since then, I've received text messages advising that they are in compliance. A reinspection will occur on the property probably today or tomorrow. They were also cited in reference to F-103.2.5, unable to gain entry to perform a fire safety inspection. That is for suite number 2422, business by the name of Chill and Ice Cream. Still no response yet. I do believe the business is back open. I'm sure it was closed for a period of time during the pandemic, and that might have been the reason why we were unable to inspect initially. We're requesting 35 days to come into compliance, $100 a day thereafter.
All right, I found the violations do exist, 35 days to comply, $100 per day thereafter.
Thank you, Your Honor.
Our next case is on page 12, Captain Robert Kasarwich, case number FC 200900013, case address 3081 Northwest 19th Street, owner Prasad USA Property Holdings LLC. Property posted 11/2/2020, posted at City Hall 11/5/2020.
And Captain Robert Kasarwich, Fort Lauderdale Fire Marshal's Office for case FC 200900013, property address 3081 Northwest 19th Street. Property was cited in reference to NFPA 150.5.2.1. The hood fire suppression system has not been inspected and tagged by a state licensed company within the last 6 months. They're also cited in reference to NFPA 111.1.5.6. That violation is complied. And also NFPA 101 7.2.1.5.3. Locks provided in the means of egress require a key, tool, or special knowledge or effort for operation from the egress side. That violation still exists today. Visited the property earlier this week on Monday. They have a company coming out to certify the hood system. Their certification report, when they do certify it, is probably going to note deficiencies just by a visual inspection that I've seen of the hood system. But we're still going to request the 35 days or $100 a day thereafter.
All right, I found the violations do exist, 35 days to comply, $100 per day thereafter.
Thank you, Your Honor.
Our next case is on page 14, Inspector Michael Jordan. Case number CE 20021010, case address 1740 Northeast 49th Street, owner Anna Nesvik. This property received certified mail on 10/17/2020 and posted at City Hall on 11/5/2020.
Good afternoon, Your Honor. Officer Michael Jordan for the City of Fort Lauderdale Department of Sustainable Development Code Compliance Division, presenting case number CE 20021010, property address 1740 Northeast 49th Street, Fort Lauderdale. This property is an RS zone single-family residential property. On February 28, 2020, officers responded to the property, referenced a complaint generated by tenants of the property operating as a vacation rental without a license. A violation of section 15-272 subsection A of the city code was observed by then Senior Inspector John Suarez and myself regarding the residence being operated as a vacation rental without a vacation rental license, amongst other violations that are being addressed via other cases. An inspection report was posted to the property, mailed to the owner's address as listed on the Broward County Property Appraiser's website. On March 16, 2020, request for special magistrate hearing was submitted for noncompliance. As hearings were suspended due to the COVID-19 pandemic and there has been no communications with the officer from the owner, this hearing was scheduled as the first available hearing. Photographs were taken at the time of inspections and are presented herein as evidence that the violation continues. As of November 16, 2020, ads are still being posted and vacation rentals of the property are still occurring. The city is requesting a declaration that the violation exists, a time frame of no more than 10 days to comply, and thereafter the imposition of a civil penalty in the amount of $500.
Find the violation does exist and the city's request is granted.
Thank you, Your Honor.
Our next case is on page 16. Case number CE 20071071, case address 2070 Northeast 63rd Street, owner Nancy Elder. This property was cited on 7/26/2020 to comply by 7/26/2020. One section complied at $250 per day, $250 accrued, and the city is requesting full amount.
City's request is granted.
Our next case is on page 16, case number CE 20071242, case address 2070 Northeast 63rd Street. This property was cited on 7/28/2020 to comply by 8/2/2020. One section not complied at $200 per day, $21,800 is accrued. The city is requesting full amount and fines continue to accrue.
City's request is granted.
Our next case is on page 17, case number CE-19110672, case address 660 East Dayton Circle, owner Eve Rosette Andre. This case was first heard on 2/6/2020 to comply by 2/16/2020, 3/12, and 3/12/2020. Suspended 3/16/2020 to 9/4/2020. Two sections not complied at $25 per day, $4,000 accrued. The city is requesting full amount and fines continue to accrue. For the record, violation 18-12A complied previously and no fines accrued on that particular violation. Thus, two sections remain uncomplied. $4,000 is accrued and the city is requesting full amount.
The city's request is granted.
On page 23, I'm sorry, on page 19, case number CE-19061756 has been withdrawn. Our next case is on page 23. The city is requesting to vacate the order of 3/5/2020 for case number CE-19070505, case address 1050 Northeast 9th Avenue, owner Todd Ashworth.
Okay, the city's request is granted.
Our next case is on page 27. Case number CE-20100492, case address 436 Northwest 10th Avenue, owner Walter Bain. This property was cited on 10/14/2020 to comply by 10/19/2020. One section not complied at $200 per day. $6,200 is accrued. The city is requesting full amount and fines continue to accrue.
The city's request is granted.
The city is requesting that page 32 be entered into today's hearing as an exhibit. It is the city's list of complied, closed, withdrawn, and rescheduled cases.
City's request is granted.
This concludes the special magistrate virtual hearing for November 19th, 2020.
Happy Thanksgiving, everybody.